Thank you, Your Honour. Good morning, everyone. This hearing is in the matter of case number CFI 009-2023 before Justice Sir Jeremy Cooke. The hearing is being held by way of video conference in the DIFC courts in Dubai. Any orders or directions made during or after the course of this hearing will be issued by the registry on the judge's instructions. The claimants are represented by Holman Fenwick Willen. Lead counsel is Mr. Sharaf Al-Shivzi, KC. The defendants are represented by Jones Day. Lead counsel is Ms. Heather Martin and Mr. Philip Devonish. Thank you, Your Honour.
Yes, Ms. Martin.
Thank you, Your Honour. Might I suggest that as a housekeeping matter, we address the letter we sent to the registry on Monday, I believe, regarding the creditors meeting that the liquidator has called?
I haven't seen that.
Okay, it can be found at the hearing bundle at page 8360.
Yes, well, I had a quick read of that.
We would just be grateful for some direction from the court. I know the court queried what the process might be going forward, and the liquidator has called a creditors meeting. We're just mindful of the fact that this court tends to issue its orders quite quickly, so it's not entirely certain that the liquidator will still be in office during the time of the meeting he's called, and if so, or if he's not, what that does to his powers to call such a meeting at that time. The court rightfully noted that the parties might have a difficult time, or that the creditors might have a difficult time agreeing on a replacement liquidator. So we've asked the liquidator through his solicitors what process they plan on using, and they weren't really very specific with us in their response to us. And so we're just mindful that this all might end up back at the court anyway, and so it might make sense that rather than going through all that, the court just set directions. One other thing that we would ask is that in order to nominate someone, whether it be at a creditors meeting or for the court's consideration, we need to understand the affairs of the company and the current financial picture of it. Any potential replacement liquidator is going to want to know if they're going to be able to get paid or what the sum of money is sitting there. And we just have no visibility on that because the last creditors report, I think, was as of something like August 2023?
Yes. Well, obviously, at the creditors' meeting, there would be a statement of affairs of some kind produced, no doubt.
We have not been given that assurance.
I believe so, my lord. Can I just suggest on this point that I wasn't aware from my learned friend that she was going to raise this first thing. I rather assumed that this would come up at the end of the application once your lordship had heard what's happening on strikeout. And this point might, depending on what your lordship wanted to do, this might require a little bit of explanation. So I can give that now, but it's a matter if your lordship would prefer to get on with the strikeout summary judgment application, then we can deal with that later.
Well, I should have thought the natural point to deal with this was at the end, but the parties have the opportunity to think about it as to what would be the most sensible course. and I think the right thing to do is probably to deal with it at the end. But self-evidently, there's got to be a statement of affairs of some kind.
Yes.
So that people know where they stand.
Yes. Well, we agree with that, my lord.
Is there any particular reason, Miss Martin, for dealing with it right now?
No, it can be dealt with at the end. I guess the one additional concern I would have about receiving a statement of affairs at the creditors meeting is that the procedure they've set forth is that we need to nominate potential replacements in advance of that. And it's very difficult to have those conversations if you don't have a statement of affairs to talk about.
Yeah, all right. Well, I'm conscious of that, and what you say makes sense. The earlier the statement of affairs of some kind is produced, the better. Let's deal with that at the end, and we'll find a way forward. So far as otherwise as timing is concerned, what's the anticipation of the parties?
I was anticipating that we would cover security for costs very briefly next. We don't have a lot more to say on it. Our pleadings are in, but I just thought we could get that out of the way so that we can concentrate on strikeout.
Yes, and then
Okay.
no, wait, Mr. Schiff.
Sure, of course. I'm so sorry.
And then how long do you anticipate being?
I do. Well, I was hoping that we could go through 3 of the purely legal issues up front at the hearing today, because I think that they have the ability to narrow what we say after that. And what we say after that, again, it might be able to be shortened depending if the court has a view on those 3 topics. If it doesn't, then I would anticipate taking the balance of the day today.
Right. Okay. I'm on the security of costs. There's really not much to talk about, is there? I mean, it seemed to me, taking a provisional view only and not wishing to preempt any argument that is truly necessary, there ought to be a provision for notification of termination, should that occur, and then simply liberty to apply would be the easiest thing, wouldn't it? Would that meet the bill? I know there's issues of costs, and we can deal with all that subsequently, but in terms of going forward.
Could I just ask Mr. Devenish to address the court on this very briefly?
Yes, Mr. Devenish. Very briefly at this stage, please. Because really what I'm interested in is whether we need to deal with it all now or whether we should just get on and sort out the details at the end.
No, you're absolutely right, Your Honour, in that the most of the problems that we had identified with the insurance policy will be remedied by the endorsement that the claimants are willing to execute. It's just those 2 lingering issues from our side. The notification point, which Your Honour rightfully raises, and also we've asked that the court direct the claimants to assign the policy to the new liquidator once he or she is appointed. There's a concern from our end that either that assignment won't be made, or at least it won't be done in a timely fashion. So we thought an easy fix for that would be if the court directs the claimants in that way.
All right. Well, I've got the message. I don't think we need to explore that for the minute. We'll come to the formal orders that have to be made when we've resolved the more substantive issues, I think. Unless Mr. Shifty wants to say anything else at this stage.
No, my lord. I mean, the security for costs is actually irrelevant if my learned friends are right that the entire action should be struck out. So it makes sense to deal with it at the end. But as Mr. Devenish has fairly conceded, there's nothing between us apart from this point of termination. On that, of course, if this termination would be content and it would be appropriate for us to give notice. And on the assignment point, I'll need to address you on that, but I suggest we do that at the end.
Yeah. I'm self-evidently, if on a change of liquidator there's no policy, then everything's up for grabs again. So it follows as night follows day. All right. Well, let's move then to the real issues for today. I've read the skeletons. I've read in part the authorities that are referred to, and I've read all the witness statements. I haven't necessarily read every single document that's referred to in the witness statements. So take your cue from that, Ms. Martin.
Well, thanking the court as always for its thorough preparation. our grounds for strikeout or summary judgment rest either on pure points of law, a bare comparison of what is pleaded to the law to determine if it makes out a claim, or in limited circumstances, discrete issues of contractual construction or limited observation of facts that are unlikely to change at trial because they demonstrate the fancifulness of the particulars as pleaded. So for purposes of this application, we take the claimant's pleading, the particulars specifically at its highest, and what it would be capable of sustaining if the facts pleaded therein are proven. Now, contrary to the claimant's repeated suggestion in their skeleton, taking the claimant's pleading at its highest for the purposes of certain arguments for strikeout and immediate judgment cannot reasonably be interpreted as a concession of the asserted facts for the purposes of a merits hearing at trial, nor something that is not positively denied or specifically refuted in our skeleton or during this hearing be taken as admitted. Now, despite the generous 40-page skeleton limit that the court granted, we did have to work with an economy of space for the purposes of making an application for strikeout and immediate judgment on this lengthy particulars, and we consider it completely unorthodox and inaccurate for the claimants to then suggest that any point not raised in the application should be taken as admitted, conceded, or abandoned. So the approach the defendants have taken is consistent with the practice direction in this court, saying that parties are not expected to put everything in the skeletons, but just to set forth the framework to be developed at oral argument. But for the sake of tidy housekeeping, and without abandoning any of our defenses, for the purposes of this application, we are not explicitly pressing two of the points that were in the original application notice. And those are the incompatibility of claims under the law of obligations and the contract law, and the unlawful means conspiracy not being a cause of action in DIFC law. So we suggest that each party argues its submissions on three topics at the outset because of their ability to significantly narrow the later discussion in the event the court is prepared to rule or at least give an indication on any or all of them. And the three we would suggest are retrospectivity, statute of limitations, and the existence or non-existence of three claims in DIFC law, which would also eliminate the need to substantively address them. So dealing with retrospectivity first, the DIFC Court of Appeals in the industrial group case issued a clear ruling against the retrospective application of substantive statutes.
Ms. Martin, I'm sorry to interrupt at such an early stage, but
Sure.
does very much turn on this. As I see it, whether one looks at the company's law or the insolvency law in 2009, 2019 or whatever, it's not going to make a lot of difference to the courses of action, is it? There's only one it seems to be it impacts on, isn't there?
Well, the duties expand quite significantly from the 2009 companies law to the 2018 companies law, provide a much more extensive description of the director's duties and contain a duty to avoid conflicts of interest, whereas the prior version of the company's law only contains a duty to account. So we would say that these are substantive expansions.
I just can't see that it's going to make any real difference when you look at the essence of the claim, which is that in breach of their duties, however they're expressed, the directors were party to conspiracy to take away the business of the company, dissipate it, in favour of BJSSAM. And that's the essence, the point. And whether or not the duty is simply a duty to act in good faith in the interest of the company, or has all the relevant sub-particulars of the later legislation, I can't see that it really matters. Am I missing something?
Well, we would say that the differences affect what standard the individual defendants were expecting to be held to when they held the office. We do consider that the later company's law is much more expansive, and one cautionary point I would say is that the way that the particulars are pleaded is that it does sort of just throw out all these duties and say whatever they are, and then give sort of like a menu of facts. And it doesn't really match any particular facts to any breach of duty. It just says that this combination of facts paired with this combination of duties leads to some breach of duty for which there's a remedy. We say that that's not an appropriate way to plead a case, that there should be a clear duty and expectation set out, a clear set of facts that breaches that, not by reference to an amalgamated scheme, and that each director can then understand what it is that's being levied against him. I won't make too much of the point. We don't.
Well, I've just summarised to you what I think Mr. Shivji's case is, as I've understood it, which is that all these directors participated in a combination, a conspiracy, an unlawful conspiracy, whereby the assets of this company were depleted and moved elsewhere, and in particular moved to BJSSAN. Now, I mean, isn't that the essence of what we're talking about? And that's either right or wrong.
Well, it is the essence. We would suggest that pleading standards are, particularly for fraud cases, require particularity, and
Yes.
That isn't it. Like, the essence doesn't do it. We need to understand what the particulars are, including what law it is that they're being held to, whether or not it's the one in force at the time or a later one.
Well, I don't understand that point. I mean, all that's a matter for argument at the end of the day. But as long as you know the case which is being made against you, which that these directors, in the knowledge of insolvency, likely insolvency, probable insolvency, imminent risk of insolvency, whatever test you think is now appropriate in the light of the authorities, participated in a scheme to dissipate the assets of the company and thereby to defraud the only creditor that matters in this context, which is Al-Kharafi. You know, the essence of the case seems to me abundantly clear. The directors know what it is they're accused of, and as yet, and the CEO, of course, and as yet, none of them have actually troubled to go on witness statements to say anything about it, which presents a bit of a problem from my perspective. I mean, I understand as soon as you get to factual issues, you know, that the whole of the strikeout and summary judgment disappears. But the only thing I'm interested in today for strikeout is there a sustainable claim on the face of the pleadings, assuming, as you rightly say, as we have to for these purposes, that the facts pleaded are proved. And that's the essential fact that is being suggested.
I thank the court for raising the CEO, because the other thing that is impacted is that the definition of director changes between the laws, and the claimant's pleading is that Mr. Carton, the CEO, was a de facto director at the time.
Yeah.
Now, they pin that to what is the sort of third definition in the 2018 companies law, but that definition doesn't appear in the older law. And so while, again, this would require getting into a factual issue, if you look at factually what Mr. Carton was doing, he wasn't attending board meetings as a director, he wasn't voting as a director, he was taking his direction from directors and then acting as CEO. The way that the claimants would construe de facto director in this case would make every CEO or SEO in this jurisdiction a de facto director. We say that's not right, but in any event, we say that that's not even available to them under the older law. Like, we treat him like the CEO and with whatever duties applied to him in that role, but not as a director.
Well, he has a duty to act in the best interest of the company too, as an employee, senior employee. So again, does it really matter? I'm not sure whether there are such things as de facto directors under the old law or not. What's your position on that?
Our position is there's not. The definition in the old law is a person occupying the position of director of a company limited by shares, by whatever name called. He wasn't occupying that position. There were always 5 director seats. They were always filled by other people. So does he have other duties under the law of obligations? Sure, but that's still a separate statute that we'd like to be able to separately refer to. It doesn't make him a de facto director under the company's law.
Well, I understand that, but I don't think it's going to impact in the end on his duty not to take part in a conspiracy to deplete the assets, if that's you know, what is ultimately shown to be the case. I mean, what I'm not understanding, and it's true of a great deal of the points you raise, Ms. Martin, is whether any of them really matter in the overall context of this case.
The only other point I could make about whether or not it really mattered is the new company's law explicitly says that directors' duties, or at least one of them, the duty not to, I think it's to leverage conflicts or confidential information, persists after a director resigns. Yes. That does not exist in the old law either. So that may matter for Mr. Sassoon, whose resignation was effective in February 2014, after which he negotiated the wind down on behalf of the shareholder.
Yeah, well, negotiation raises a slightly different point, but it's a bit of a make-weight point anyway, as I see it. But at the end of the day, as I say, it doesn't really matter what the particularities of the duties are in the context of the main claim, and all those points can be argued fully at the end of the day without really impacting on what we're about today. I mean, there's very little purpose served, I think, Ms. Martin, in me striking out one paragraph that deals with negotiation of the breakup, for example, to take the point you've just raised, and doesn't really achieve anything much. Of course, I'll do it if I'm satisfied that's absolutely essential, but and what I'm trying to do is to get you to focus on what I think the real points that matter are, if I may be so rude as to say so.
Oh, I don't take it as a read at all. I appreciate it, and I shall move on that basis. So we'll move on to time bar. Now, this court has previously considered whether Article 9, sub 1 of the Law of Obligations extends ad infinitum the statute of limitations applicable to allegations where dishonesty is alleged, but fraud is not an essential element. And Justice Steele swiftly disposed of the argument. I'm referencing page 6643 of the bundle if the court wants to follow along, that in paragraph 38 of the 2016 Al-Kharafi case, he said, the claimant contends that Article 9.1 applies to a deceit claim, but is not limited to it. The argument goes on to contend that it is not limited to claims of which fraud is an essential ingredient, but applies where, as a matter of pleaded fact, the claim has arisen from the defendant's dishonesty. For this purpose, a distinction is drawn between arises from, which is said not to imply that the foundation of the claim is fraud, in contrast to based upon fraud, as used in Section 32(1)(a) of the English Limitations Act 1980, as construed in the Beeman case. I'm unable to accept this submission. The claims other than deceit are time barred. This approach, of course, accords with the English position, which has been settled law for 75 years. I see that the court's still reading. I'll stop there.
No, well, I've thought about this point.
Okay.
Of course, I'm not bound by what Sir David Steele said, and I confess I'm troubled by it because the wording's different. That was that the full extent of his reasoning in that paragraph?
Let me just refresh myself, if you don't mind.
Yes, sure. I've lost the paragraph now.
Paragraph 38.
Thank you.
My lord, paragraph 12, he actually explains what the underlying claims were, and that's relevant to this analysis as well. So the claims that he was being asked to deal with were negligent breach of duty and negligent misstatement. That's paragraph 12.
Yes. Well, that was the very point I was about to raise with Miss Martin, in fact, that if one took an example of misrepresentation, if you allege fraudulent misrepresentation, would you accept that that is something that plainly comes within the no limitation rule, so to speak, even though you could have alleged it as negligent misrepresentation and therefore misrepresentation or under statute that could achieve much the same result?
I would need to read the statute, I'm sorry, in order to form a view on that.
I was thinking about the English Misrepresentation Act, but let's just focus on the difference between negligent and fraudulent misrepresentation. If you were seeking damages, let's say, as the remedy in either case. If you plead fraudulent misrepresentation, are you subject to a 6-year time limit, or aren't you? Answer, obviously you're not if it's fraudulent, because that's what deceit is. And I think that follows from what Mr. Justice Steele was saying.
Yes, the fraudulent misrepresentation
question,
is, my apologies.
By its nature, that's what it is. Yeah. So if you plead that someone has fraudulently participated, let's use a different word, unlawfully conspired to deplete the assets of the company and thereby to defraud the company and its creditors of its assets, is that not within the exception to the 6-year rule?
The English position on this is that unlawful means conspiracy is not necessarily, it doesn't necessarily sound in deceit or fraud. You can have an unlawful means conspiracy that is unlawful by some other means. But it's difficult for me to separate what the court is saying from the description in Beeman, in the words of Lord Green, which is page 2189. Which it says it must be borne in mind that section 26 is of general application and applies to every sort of action which is affected by the act. That's the extension of the statute of limitations. Of these, many can properly be said to be based upon fraud. For example, an action for damages for deceit and an action claiming rescission of a transaction brought about by fraud. In all such cases, fraud is a necessary allegation in order to constitute the cause of action. In other actions covered by the Act, fraud is not a necessary allegation, and all of the action of conversion is one of them. Indeed, the word fraudulent in connection with conversion, however important it may be in a criminal matter, and I want to focus on that for a minute, is in the civil action of conversion, so far as regards the cause of action, nothing more than an abusive epithet. I am of opinion, therefore, that the language of paragraph A means what it says, and that the action was not based on fraud. Now, where they make the distinction here that if you put fraudulent in front of it and that becomes important for a criminal cause of action, that I believe creates a sort of constitutional jurisdictional issue for this court, because it's well understood that the DIFC court does not have criminal jurisdiction. And so for it to essentially legislate from the bench that fraudulent breach of fiduciary duty is fraudulent by its very nature and therefore subject to a different statute of limitations, is in a way taking upon itself criminal jurisdiction in a common law manner that just, I don't believe is allowed by the statutory scheme here.
Well, we're interested, aren't we, in civil fraud, not in criminal fraud, and this court has no criminal jurisdiction, so self-evidently.
Correct, but the drafters of the legislation here know how to draft a fraud provision when they want to. I mean, they've drafted fraud provisions into the insolvency statute. There are other, allegations sounding in fraud that are available to claimants here. It's just that these claimants happen to choose breach of fiduciary duty and try to turn it into a fraudulent cause of action when on its face it just isn't one. It's not an essential element of the claim.
Right.
So, and I think perhaps a helpful distinction is that going back to the Beeman case, that there were two subparts to the statute that they were considering, and one of them was just sort of standard fraudulence, and then there was a fraudulent concealment of conversion, and under that subsection, they did say that it had as an essential element fraud because the concealment element brought it under that umbrella. So the court did say that it was concerned about the fact that there is different language, and we say that the language is sort of a distinction without a difference for this purpose. In subsection 26, the language at issue is if the action is based on fraud of the defendant, whereas here as the law of obligations is a cause of action arises as a result of fraud by the defendant. So I'm not sure how the difference between based on and arises as a result from salvages the claimant's position.
Well, there is a difference. The question is different words. Sir David Steele simply says, as far as he's concerned, there isn't a difference. That's it, isn't it? Paragraph 38.
Correct.
Yeah. Okay. Well, I have the point.
So on the particulars pleading, the last day of conspiracy was 14 April 2015. And taking the causes of action here one at a time, breach of fiduciary duty is found in the law of obligations at Article 160. And it reads, where a fiduciary breaches his obligation of loyalty, he is liable to pay damages to his principal in respect of any loss suffered by the principal in accordance with the law on damages and remedies, and he is liable to account to his principal for any benefit he's acquired in consequence of the breach. Fraud and dishonesty are not essential elements of these claims. Unlawful means conspiracy is found in the law of obligations, Article 36, and it reads, where two or more persons conspire to do an unlawful act with the intention to cause loss to the claimant, and loss is caused to the claimant by the performance by at least one of them of the unlawful act, they are jointly liable to the claimant. The act is only unlawful if the claimant would have a right of action as a result of any one person performing it. Again, fraud and dishonesty are not essential elements. And thus, while the cause of action calls for unlawfulness, it doesn't fall within the extension of the statute of limitations. And misfeasance, although it falls under the insolvency law, at least in England and Wales, the position is that its limitation runs from the date of the alleged wrongdoing. It's different from other insolvency statutes in that regard. And thus, its statute of limitations, if the court adopts the same position, begins to run in 2015 as well. There's a case that's really on point on this on England and Wales that we cite. It's the Eurocrete case. And that can be found at page 3577 of the bundle. So if the statute of limitations, if the court accepts our statute of limitations argument in this regard, it would leave only the insolvency claims aside from misfeasance. Now, turning to the office holder claim extension, the office holder claims were initiated on the 1st of February 2023 by way of an application notice with a supporting witness statement. And it was Mr. Hayter's first witness statement. The application notice stated that no hearing was required and that none was set. This was also requested in Hayter 1. Now, there was no mention in the application nor in Hayter 1 that the limitation period would expire according to their calculations on the 21st of February 2023. Generally, service requirements for applications is that they be served at least 14 days prior to the first hearing. But of course, in a circumstance where they don't check the box saying that we want a hearing, no hearing date was set. But where an applicant requests to adjourn a hearing that is set for whatever reason, they're required to apply for an extension of time, in which case it has been held that it is an indirect application of the standards in Cecil and Bayat apply. But here, by not requesting that hearing was scheduled, this in effect had the ability of tolling the limitations period until they affected service. We cite the case Kellcrown Homes on page 6239. It's a leading authority relied on in respective insolvency applications where adjourning a hearing has the effect of extending time for service, and where it is argued that it deprives the respondents of a limitations defense. And I would direct the court's attention to paragraphs 29 through 31.
Where do I find that?
Page 6239. Very bottom of the page. And the reasoning it goes on through paragraph 56. If the court is not inclined to read all of that right now, the two paragraphs that I would focus on for present purposes would be paragraphs 29 and 31, where it says, it is clear that the application to adjourn the first hearing of the substantive application made without notice was an application to extend time for service of the application. In my judgment, the impact of that extension of time for the service of the application did have the effect of withdrawing from the appellant a potential limitation argument. Now, the court goes on at some length to describe delay on the part of the liquidator in instituting the claims and then getting them served. And that fed into the court's decision there. So focusing particularly on paragraph 53, it says, in this case, liquidators did not issue proceedings until a matter of days before the limitations expired. Prior to that, they had raised issues in correspondence. In July 2013, it goes on and gives some details about what they did and didn't do. But it appears, therefore, that within a week of being informed that liquidators' interest in a number of transactions, that one of the people that he intended to serve was willing to assist, and then the next correspondence from the liquidator was not until early 2015. So it resonates with some of the themes we've seen here of delay and gaps in communication from the liquidator, and that ultimately being the cause of running up into the statute of limitations. So we would just simply note on this basis that the service of all the defendants took place after the limitations period expired, but this is particularly concerning as regards the individual defendants for whom the claimants did seek an extension of time to serve because they went through diplomatic channels. And so we did preserve in relation to their extension of time application this argument in paragraphs 20 and 35 of our skeleton with regard to the extension of time for the first through third defendants.
I'm not sure I'm understanding this point, present Ms. Martin. Can we just go back to basics?
Sure. So the basics are the way that service requirements for applications in this court work. They say the claimant needs to have served it by 14 days before the hearing is set. Right. And so for a heavy application of this type, one would expect that there would be a hearing and that a hearing would be requested. There's no realistic basis on which an application as substantive as one supported by this particular of claim is not going to have a hearing. But by declining to check that box, what they did is they gave themselves the 4 or 6 months to serve the claim form, right? So it's, if they had done it otherwise, they would have submitted it to the registry. Presumably the registry would have put something on the books. And then if that hearing, let's say, is, or 2 weeks before that hearing falls after the date of the expiry of the statute of limitations, what this court says is that by seeking an extension of time to serve the application form, they are also seeking an extension of time past the statute of limitations. They're seeking to extend it, and that doesn't accord with the purpose of the service rules.
Well, again, I'm still not fully understanding this. Your complaint is that the extension was granted without a hearing, correct?
No, our complaint is that the extension prejudiced a limitations defense. They filed their claim a couple of weeks before limitations ran on the officeholder claims.
Yes.
Right. So they file on, I think, the 1st of February. They expired on, I think, the 21st or 23rd of February, and then didn't endeavor to serve anybody until May.
So what?
So if they had checked the box that said a hearing is requested, which one would expect in these circumstances, the registry would have set a hearing date and service would have been due by a date certain, which is 14 days before that date.
Yeah, but they didn't. I mean, your complaint is that there wasn't a hearing.
Our complaint is that a hearing date was not set and thereby extended the statute of limitations for a significant period of time, which the English court says you already get a generous amount of time to serve this. And the limitations period is generous. And so if you take a generous 6-year limitation period and then give yourself the flexibility of extending that limitation period by just declining to check a box so that no hearing date gets set, to give yourself the flexibility to serve it whenever you want to, and then wait months, even such that you have to file an application for time to extend service, that prejudices a limitations defense, according to the courts in England and Wales.
I must be being very dense indeed, Miss Martin. I'm just not following this at all. The claim form is issued in time. It is then served within the validity of the claim form for service. Is that right?
Well, we need to go back to before the cases were consolidated. So we had the claim form on the one hand in the fiduciary claims case, and then the application notice within the context of the insolvency proceeding.
The application notice being to do what?
The application notice being the document by which the insolvency claims were brought. Right. So technically, the claim form, although it actually contained the insolvency provisions as well, my understanding of how they structured their pleading is that the claim form really only brought the fiduciary claims, the breach claims, and that it was the application notice, because their view was that the only way to bring an insolvency or these office holder claims was as an application within the context of the insolvency proceeding. Right, so the service of the claim form is not actually the thing that matters when it comes to the application. It's the service of the application notice itself, and it's the rules of this court that say that that needs to be 14 days before the hearing is set. But it gives claimants wide berth to wait till the very end of a limitations defense and then just give themselves what is really an extension of that limitations defense if the court comes back and says, you don't need to check the box that says you want a hearing even on a heavy application. We'll just grant you an amount of time until, for whatever reason, a hearing gets scheduled. And then service only needs to be effective before then. That is an effective extension of the limitations period, which we say is not merited and other courts have rejected. Is further discussion on that merited, or?
Well, I'm just not able to follow the point, but I'm hoping we'll come back to it in a way that I will understand in due course.
Okay.
I mean, it may be that I just haven't, but I think we better try and sort it out right now and make sure I've understood what you're saying.
Okay.
We have here, now we have CFI 0092023. We had originally a 2016 claim, did we not?
We did.
Now, let's just go back to the starting point. I want to be quite clear what it is that you're saying about when limitation expired and what the technical position was as between the two claims and the consolidation or whatever it is that I have previously ordered of the two claims.
Sure. So as to the breach claims,
Can we talk about let's talk about the 2016 claim
Sure.
form and the whatever date it is, 2023 or whatever.
Yeah, February. We took it from their evidence.
Yeah, where are we looking at?
I believe it was in Braganza 1. Hold on one second. I'll get that citation for you. No, sorry, it was Hader. No. Braganza 1, paragraph 33I. I'm not actually even sure if this is in the bundle. Hold on just one second. Oh, 35I, apologies. Our apologies. So Mr. Braganza's witness statement did not make it into this bundle, but just for the sake of pleading simplification, we didn't redo the calculation on what they said. The statute of limitations ended at because there was, as the court will recall, a significant period where the parties were subject to a standstill agreement, and so it was not 6 years to the day from his appointment. It was 6 years plus the standstill period. They say that ended on the 21st of February 2023. So that is when the statute of limitations on the insolvency claims ends, according to their calculation. And so they submit the application notice, and as the court is aware, because we have submitted application notices where we didn't think a hearing was necessary, and the court queried and said, "Are you sure you don't want a hearing on this?" And so we're of course always happy to entertain the court with a hearing, but we would expect something as heavy as an insolvency proceeding alleging fraud to request a hearing. They did not do that. Now, if they had done that,
I'm sorry, you're going to have to take this very slowly. The application notice is where in the bundle, and what is the application notice?
Sure.
It's to do what?
The application notice is the document by which they bring the insolvency office holder claims.
Okay.
And it is early on.
Okay.
Page 17. No. '84 through '86.
8436.
No, 84 through '86.
Oh, I'm so sorry.
So if you go to details, it says, "How do you wish to have your application dealt with?" And it says, "Without a hearing."
So the issue date is the 1st of February.
Correct.
So we are back to the point I was asking about. I'm not quite understanding. Your complaint is that they didn't ask for a hearing when you say they should have done.
Well, what I'm saying is, if they had asked for a hearing date would have been set, and there would have been a date certain by which they needed to have served this application notice.
I understand that, but that's to do with service. We're talking about the date of the issue, aren't we? Isn't that what matters?
Right, but the courts, what Cal Crown specifically looks at is whether or not a party who waited as long as, frankly, this claimant did, is entitled to an extension of service under the circumstances. And what that court said is no, they're not entitled to an extension of service because it has the effect of also extending the time for statute of limitations. And they say that the limitations period is very generous, and that you shouldn't get to add the period for service on top of that. That creates unfairness to defendants. That basically the claimant should have been more diligent, and the claim was time barred as a result.
That's in a situation where the claim form has a validity of a period for service. And if you don't observe it, then you have to get an extension. That's the point, isn't it?
Correct.
And if you don't get the extension, then the claim form expires and you have to start again and you'd be out of time.
Correct.
Hence the deprivation of a potential limitation defense. But I can't quite see how if that arises here, where you've got an application notice that's issued in time without any specific period required for its service other than 14 days prior to a hearing.
But if they had checked the box that said a hearing is required, which I think we can all agree one is required on these allegations, then there would have been a specific period within which to serve. And if they hadn't served within that period, then they would have been required to file an application for an extension of time to serve, which on the logic of this case says is an effective extension of the limitations period and should not be granted.
Yeah, well, I have understood your point, but I can't quite see how it works. But there we are. I will think further about it.
Thank you. And then the third topic I wanted to address at the outset is claims on which our position is that they do not exist in DIFC law.
Right.
And those are dishonest assistance, knowing receipt, and misfeasance.
And by misfeasance, you mean misfeasance as a director as opposed to misfeasance under the insolvency regime?
No, I mean misfeasance under the insolvency regime. As Your Honor has rightly observed, the DIFC court and law is statutory, and if a substantive claim does not appear in a DIFC statute, it is not part of DIFC law. We rely on the industrial group case of the Court of Appeals, and that can be found at, I believe, 7700. No, sorry, apologies. 7676. And actually turning to paragraphs 103 and 112. Oh, sorry, 105, which is $7,700. I had it right the first time.
7,700.
Now, there the court was confronted with the question of whether malicious prosecution and abusive process were torts that exist in DIFC law by virtue of the waterfall provision of the law on the application of civil and commercial laws 2004. And the court said in paragraph 105 that it does not, however, follow that DIFC court judges are free to incorporate into DIFC law any common law development from any common law jurisdiction simply because there has been such a development elsewhere, and because the outcome might prove attractive to the judges sitting on the individual case. It is to be kept in mind that from time to time, different approaches are adopted in different common law jurisdictions. Internationally, the common law is by no means necessarily uniform. The DIFC courts do not and could not sensibly import all foreign causes of action. Properly analyzed, though the DIFC courts are common law courts and DIFC law is to be interpreted and developed incrementally in accordance with the methodology of the common law, the basis of the DIFC court's jurisdiction is statutory. And of course, citing a case that your lordship authored. Now, we accept Mr. Montague-Smith's submission that a statutory basis for the court's jurisdiction is inevitable, given that the DIFC is a financial free zone with its own law, comprising a carve-out from or enclave within the UAE and Dubai legal systems. Reference must therefore be made to that statutory framework to ascertain the scope for proper judicial interpretation and development of DIFC law, and to avoid straying into impermissible judicial legislation. Where DIFC statutory law identifies principles which come from other jurisdictions, it is legitimate to look to those jurisdictions to determine the content and principles in question and their appropriate incremental development. Beyond that, and in general, as observed in DIFC Courts Practice 2020 edition at page 87, DIFC courts have shown real determination in properly resisting invitations to make judicial legislation. In our judgment, having regard to the statutory framework incorporating the torts into the DIFC law by way of judicial decision would amount to impermissible judicial legislation. Now, the case that your lordship authored that they are citing, just by way of reminder, is paragraphs 12 through 18 that we would look to. And the quote that they took from there was, "The basis of this court's jurisdiction can therefore be seen to be statutory and wholly dependent on these provisions. Whilst this court is a common law court, there is no basis for incorporation of a body of substantive common law, whatever that may mean, into the substantive law, which falls to be applied in the DIFC." So applying those principles here, dishonest assistance, knowing receipt, and misfeasance simply do not find substantive causes of action in the law of obligations. As the Court of Appeals in the industrial group said, overall, and this is paragraph 112, overall, on the materials before us, we struggle to find room for the importation of a substantive tort. Procedural and evidential matters might be different into DIFC law. If not contained in the law of obligations to such extent, at least, the law of obligations comprises a code. For completeness in our judgment, the torts are indeed substantive torts, even though their subject matter is focused on court proceedings. Realistically, it could not be maintained that these torts are procedural only. So now, the claimants do try to cite to certain DIFC statutes to underpin these claims, but they also cite the DIFC common law of trust and equity and/or DIFC law generally. We say that these are not adequate bases for substantive causes of action. In addition, the statutes that they cite cite to remedial provisions and not substantive ones.
What do you say about Article 11 of the Trust Law then?
Article 11 of the Trust Law.
Yeah.
We say that it doesn't give the court the right to impute substantive causes of action, contrary to what the Court of Appeals held in the industrial group case. To do so would be directly at odds. That would just be a free-for-all. So principles of equity in interpreting it, certainly, but substantive causes of action according to principles of equity, we would ask the court to reject that. So they also cite from the trust law, Article 59, and then Article 35 of the Law of Damages and Remedies. So taking those one at a time, Article 59 of the trust law is titled Remedies for Breach of Trust, and specifically provides to remedy a breach of trust that has occurred or may occur, the court may. It does not purport to create a cause of action, nor should it be construed as doing so, as the provision directly preceding it defines what constitutes liability for a breach of trust. Article 59 can be found at page 3327 if the court is interested. I don't think that Article 58 made it into the bundle, but I do believe that the table of contents shows that the article immediately preceding it spells out liability.
Yeah.
So in the event it is the claimant's contention that the facts of this case involve the knowing recipients being construed as constructive trustees, there is law foreclosing this argument, and I specifically refer to Williams versus Central Bank of Nigeria, and that can be found in the bundle at 5465. And there the court distinguished two types of constructive trustees, those who act in a de facto trustee role by virtue of a lawful transaction, and those who are not in fact a trustee at all, even though he may be liable to account as if he were. The latter never assumes the position of trustee, and if he receives the trust property at all, it is adversely to the plaintiff by an unlawful
Sorry,
transaction.
where are you reading from?
This is on page
This is all for the purpose of Limitation Act. It's looking at the law of limitation in relation to trust. Is that right?
Yes, but it's construing who's actually a constructive trustee, and it goes into some detail about how.
Go on. Which is the relevant paragraph?
Apologies, I failed to note the paragraph number in my outline, and we're just looking for it now. Paragraph 9, beginning at 9. No, apologies, 11.
Okay. Yeah, but I mean, all of this is in the context of deciding how the Limitation Acts apply in relation to a breach of trust, isn't it?
It is, but the analysis in terms of that the terminology has gotten a bit muddled is helpful here, I believe, because as they say at paragraphs 35 through 36, that the court reiterates that knowing assistants and knowing recipients are not true trustees and are both claims based on a theory of partially primary liability for their part in a fraud. So for this reason, dishonest assistance and knowing receipt are properly regarded as substantive claims and cannot be shoehorned into general remedial provisions for a breach of trust found in Article 59 of the Trust Law.
Paragraph 35, is that, did you say?
Paragraph 35, Article 59 of the Trust Law, sorry. Or you were saying in the opinion? Yes,
Yeah.
35
Yeah.
and 36.
Thank you.
Page 5485.
Yeah.
Now, Article 35 of the Law of Damages and Remedies similarly, specifically falls under the remedies section and provides where a person commits a breach of any requirement, duty, or obligation which is imposed under any DIFC law, the court may. Then it gives a menu of options that the court may undertake. Now, no duties or obligations are found in this provision, and there is no basis for interpreting this as giving rise to a cause of action. Dishonest assistance and knowing receipt thus find no statutory basis and do not exist in DIFC law. The misfeasance claim also attempts to create a substantive claim on the basis of a remedial provision. Article 80B of the Insolvency Law 2009, which I will cite throughout my outline just for the sake of convenience, states in this.
I'm so sorry, Ms. Martin. I was focusing on something else. Can you repeat where you were going? You're dealing with misfeasance now. Certainly,
dealing with misfeasance now. And it also attempts to create a substantive claim on the basis of a remedial provision. So I was turning to Article 80B of the Insolvency Law 2009, which can be found at page 3710.
Yes.
And it states that the court may, on application of any aggrieved person, including a liquidator or administrative receiver, make any orders as the court sees fit in relation to a person to whom this Article 80 applies. Now, whom it applies is defined in the preceding Articles 73 through 79. So I would just ask the court to scroll through and take a look at the structure, because every single one of those, and that's on starting on page 3709. But every single one of those has a provision that says when these things are present, then Article 80 applies.
Yes. Yeah.
Article 80, therefore, does not create an independent cause of action, but is expressly confined in its application to remedies for breaches of Articles 73 to 79. And so even if we were to look at the 2019 law, Article 15 is titled the remedy and provides that the court may make any orders as the court sees fit in relation to a person whom this article applies. And then it's Articles 107 through 113 that explicitly state when it applies. So it's the same verbal formula. Now, this stands in contrast to Article 212 of the Insolvency Act, which I would anticipate the claimants will say applies by analogy. Let me get a page number for that. 2508. So this is self-referential in terms of who it says it applies to. The very first line is this section applies if in the course of a winding up of a company, it appears that a person who, and then it goes on, and then it gets to section 3 and says what the court may do. There are no other surrounding statutes that say that this statute applies when their requirements are triggered. So it's very different in structure from the DIFC law.
Mm-hmm.
We would say that these 3 claims should be stricken out on the basis that they do not exist in DIFC law.
Yep.
Now, my initial suggestion was it might make sense for us to cover these 3 points because they're sort of sharp legal points that if the court has any indication of where it is leaning on them, it might serve to narrow what we discuss later, but I'm not sure if that is appealing to the court or to Mr. Shuji.
How does this help for later issues?
Well, if we are eliminating things that we need to talk about, then it just helps shorten what I have to say.
Do you want to reply on these points, Mr. Shibji?
I do, my lord. I mean, it may help shortcut matters. Obviously, it's a matter for your lordship. So maybe I can make some remarks about it, and we'll see where we get to.
Well, if you both think it's going to shorten things, let's do it.
I'm grateful, my lord. So my lord, the starting point is that although we say we're right about these 3 points and the points that they raise are bad, even if my learned friend was right, none of these points would actually curtail the trial in this matter, because what survives, even on their case, is essentially substantively the same case, the same facts, the same issues for the court to try. So we don't accept that this is a sensible shortcut. And some of these issues, not all of them, but some of these issues are quite complex, and there's quite a bit of authority on them. But my lord, with that introduction in mind, perhaps I can just run through each of my learned friends' 3 points. The first one were her points on retrospectivity. Now, we rely on both the laws. Our position is that there was no fundamental change in DIFC law as a result of the replacement laws being put in. Fundamentally, this case revolves around directors' duties. There's a body of material that shows, firstly, that fiduciary duties are applied to both directors and senior officers. Yeah. So that deals with my learned friend's first point. Secondly, that those duties would continue to exist after a director resigns, where the director has resigned in order to essentially pursue a breach of fiduciary duty. And we'll probably come to it later, but the Quartermaster case that I rely on in my skeleton makes that point. There's a number of authorities, but as a director, you can't escape a claim for breach of fiduciary duty by identifying an opportunity that belongs to the company that you want to pursue and then resigning to pursue it. Obviously, that would make a mockery of the fiduciary duty because it would provide an escape clause. So in light of those 2 points, my learned friend's argument that there is some substantive difference between the 2 laws gets her nowhere. So we say for that reason, you just simply don't need to decide this retrospectivity point now. My lord, then moving on to her points about limitation, the short answer is that all of the relevant claims are fraud claims. And it's telling that the defendants understood these to be fraud claims. And until we got their skeleton argument last Friday, their position has always been that there is no limitation defence. And in fact, that's something that they've complained about. They've put it before you when we dealt with jurisdiction. They've also complained that the theory I think they advance is that the reason that we've gone as far as alleging fraud is in order to circumvent the limitation difficulties. But now, very late in the day, more than a year after this case started, they say that there is a complete answer to all of the material claims on the grounds of limitation, and that's just plain wrong. As your lordship has identified, Article 9 is different in terms to the English regime. It also does something different because it is a one-stop shop to deal with all aspects of fraud. And under English law, there is a separate concept of concealment within the context of limitation, but that isn't dealt with separately in DIFC law. It is wrapped up again in this idea of claims arising out of fraud. So we say that there is a significance in the fact that DIFC law puts the fraud point differently as a matter of limitation. And we also say that you're not bound to follow the Karafi case, but we say that actually the judge, Justice Steele, didn't actually decide anything that was relevant to today. He was considering a separate question there about whether claims that were admittedly negligent, not fraudulent in nature, could still simply get round the limitation bar by saying that the underlying factual matter in some way involved dishonesty, and the judge rejected that. Now,
well, it's obvious that if the claim had been for fraudulent misrepresentation, that's classically deceit, classically fraud.
yes.
I mean, there's a lot of debate in English law as to what fraud really means in a civil context. I nearly always take it as meaning basically dishonesty.
Yes.
That's the essence of it. And of course, then you get into a debate as to what is dishonesty. And we've had not only a lot of debate in the criminal context, but also a fair amount in, I think, in the civil context too. But going back to the distinction that Sir David Steele was drawing, or not drawing, you say, do you, that the words based on give rise to the necessity for fraud to be an ingredient in the course of action, whereas arising out of could apply to any course of action, whether or not a necessary ingredient was fraud, if fraud is alleged.
Exactly, and that's why we thought the concealment point was also instructive, because the arising out of would capture a scenario where a dishonest defendant concealed their misconduct, and as a result, the claimant didn't become aware of it until some later stage. So we say the language is, I mean, plainly, as you say, it's different. The draftsperson of that particular law will no doubt, like many other laws, have looked very carefully at what English law did. They've chosen not to simply copy the English law regime, but to come up with another formula. And we say that formula captures the present scenario, which involve serious allegations of dishonesty that underpin each of the causes of action. But in any event, I also say that dishonesty is in fact an ingredient of the causes of action that we rely on, and I don't accept my learned friend's characterization that, for example, for a breach of fiduciary duty, a dishonest breach of fiduciary duty is the same as a negligent one. They are treated as different causes of action under English law, and so even if one applied the ingredients approach, you would still find that we get home on that. Can I perhaps on that point, my lord, I might show you the Paragon Finance case in which Lord Justice Millett made exactly that point, that a fraudulent breach of trust or breach of fiduciary duty is a different cause of action to a negligent one. And that is in your authorities bundle at page 2518. Now, in this case, it concerns the introduction of new claims by amendment, and that was after the end of the limitation period for non-fraud claims. And so there was an argument about whether there was a limitation defence to the fraud claims.
Yes.
And if your lordship goes to page 2524 at C, Lord Justice Millett says there, as he then was, in my judgment, it is incontrovertible that an amendment to make a new allegation of intentional wrongdoing by pleading fraud, conspiracy to fraud, fraudulent breach of trust, or intentional breach of fiduciary duty, where previously no intentional wrongdoing has been alleged, constitutes the introduction of a new cause of action. So his position is that that was a new and different claim, and we say that is obviously right as a matter of English law. Doesn't actually matter as a matter of DISC law, but if your lordship needed comfort that these were distinct cause of action from negligent claims, this provides it. My lord, the next point, looking at this problem from another perspective, is that in any event, under the DIFC Trust Law, Article 64, there is no limitation period for fraudulent breach of duty claims against fiduciaries. And your lordship will find that at 3328 of the bundle.
So what am I looking at?
This is the trust law, and we're looking at the top of the page. This is Article 62, sub 4. No period of limitation shall apply to an action brought against the trustee in respect of any fraud to which the trustee was a party or to which the trustee was privy. And that is essentially equivalent to Section 21(1) of the English Limitation Act 1980, and that provision applies to fiduciaries, directors, equally as any other trustee. So in any event, under Article 62, again, there is no limitation period specifically in relation to a claim for breach of duty.
How do you say this applies to a quote constructive trustee?
I don't, because when I'm not bringing a claim for breach of fiduciary duty against the, in inverted commas, constructive trustee, but it comes in then. So sorry, my lord, I'm taking it in stages, and the first stage was to persuade your lordship that the claims against the individual defendants for breach of their fiduciary duties as fraudulent breaches were separate causes of action, that there is no limitation period under DIFC law. And if I'm right about that, which I say I am, then that then gives me the underpinning for the other causes of action, which then are based on those fraudulent breaches of duty. So then when I come on, for example, to deal with the unlawful means conspiracy, there, the unlawful means conspiracy, again, is based on this fraudulent breach of duty. That is the unlawful means, and that is the ingredient of the cause of action. And again, there, if you adopt the ingredients approach under English law, that is a fraudulent unlawful means conspiracy is considered to be based on fraud.
I'm still not seeing how Section 62 is of any assistance to you.
So in my claim against the individual directors for a fraudulent breach of duty, that is a claim against a trustee. They are, for these purposes, a trustee, because the law treats directors and other fiduciaries as within this category.
I think I'd need some satisfying that that was the case. On the face of it, we're talking about, we've discussed before what trustee means, but this is very specific about, and we're talking about a trust law here, aren't we?
We are, but this replicates Section 21(1) of the English Limitation Act, and I'll just get that reference to you, my lord. This is in so this is dealt with in the first Subsea Baltec case. It's a judgment of Lord Justice Patton, and you'll find that in the bundle at 6270. And if your lordship could just read that paragraph, it explains that the concept of trustee is applied by analogy in relation to directors.
Could you please just remind us which paragraph?
Paragraph 50. And it's in particular, obviously, the sentence that says the effect of those decisions is that a director is a trustee within the extended definition contained in section 38(1) and 21, is therefore directly applicable to claims which are made against directors for breaches of its fiduciary duties. And that section 21 is equivalent to Article 62(4). But in any event, this is just a second route through to getting to the same destination. And I say my first route, Article 9, already gets to this point.
Hold on.
Sorry, Mark.
Yeah, all right, got the point.
I'm grateful, my lord. I mean, I'm not going to go through all of this ad nauseam. But just to pick up the point that my learned friend developed awfully, that unlawful means conspiracy doesn't involve fraud. I think actually I did get a precise note of her submission, but actually my recollection was that she wasn't saying it could never involve fraud. She just says it doesn't necessarily involve fraud.
Well, and that's plainly right. The question is
course.
what is the unlawful act that's complained of, isn't it?
Exactly. Exactly. But in cases where the unlawful means is a fraudulent act, that is a fraudulent claim that would again come within Article 9. And just to make good that point, that a fraudulent unlawful means conspiracy is considered to be an action based on fraud. That is covered in Cunningham and Ellis, and that was a decision of Mr. Justice Tier at 6948 of your bundle, para 95. It's just at the bottom of the page, my lord.
Yeah, thank you. Yeah.
So
I'm having trouble making a note.
not at all.
Why doesn't it want to do it? Never mind. Yeah, all right, I've got it. What's the name of the case? It's Cunningham against
Ellis. And it was a decision of Mr. Justice Tier.
Yeah, I see that. Yeah, all right, thank you.
So but now, my lord, I'm going to actually move on to deal with the insolvency claims because I'm conscious of the time. But we say this, the short answer to all of this is Article 9, so you don't need to get into this ingredients approach. When you come to the accessory liability claims, and when my learned friend doesn't even accept that they exist as a matter of DIC.
You've frozen.
Opined on the ingredients of them. But our position is that obviously for both dishonest assistance and knowing receipt, where the underlying allegation is of fraudulent conduct and fraudulent knowledge, that they are both claims based on fraud as well.
Yes, you froze for a bit there, Mr. Shipji, so I may have missed a sentence or two.
Okay. Well, I was simply saying that for both of those accessory liability claims, there is currently no DIFC judgment that considers those claims in detail, but our position is that they are claims certainly arising out of fraud and claims where, in this case, the fundamental allegation is fraudulent conduct and fraudulent knowledge.
I've got that point. You're going to deal with their existence separately, are you?
I'm going to deal with their existence separately, and I can hopefully deal with that quite swiftly. And then, my lord, there was quite a lot of time spent on my learned friend's points about the insolvency law claims and whether they were statute barred. That was a bad point. They have been. The first point is that they were commenced both by claim form and also by insolvency application notice, and both on whichever process is applicable, they were both commenced in time. There is, under the rules, no validity period for the application notice, and we say that the idea that we should have simply asked the court to immediately list it for hearing would have been nonsensical, because we obviously had to serve the application, which is what we went to do. And the court has already had to consider the question of the extension of time for the claim form, which incorporated these insolvency claims. And my learned friend made her arguments on that, and the court rejected it and extended time. And those claims were all served validly on the defendants. They disputed service in relation to the claim form, and that failed before your lordship. And so where we end up is that the claims have all been issued in time and they were all validly served. And so this argument that came up in my learned friend's skeleton argument is a bad one. But also, in any event, again, for all of the claims apart from the transaction under value, these are all claims arising out of fraud. So in any event, there would be no limitation period. So we just say that's all a bunch of bad points. Now, I don't want to labour the point, because I appreciate your lordship wanted to understand the substance, but we say that the way that these limitation points were raised is not acceptable, and we've set out in our skeleton that they really emerged from nowhere in my learned friend submissions on Friday. They weren't the basis.
I've got all that, Mr. Shipji. I mean, bottom line is, however, if at the end of the day they're statute barred, they're statute barred, you know. So whether the point was taken, not taken, it would be very hard to say that they were somehow stopped from ever raising the point. Anyway, there we are. I've got the point as to the novelty of them.
I'm grateful, but my lord, I mean, the only reason I do raise that, and we'll come back to this later, but this application has been a remarkable moving target, and it's required some agility on our side to pick up whatever new point is raised and then to shift to focus on that. And there is an unfairness to that. But anyway, I don't need to dwell on that. So, my lord, can I just come on to this third point about whether or not these causes of action actually exist? Hopefully we can deal with that pretty swiftly. So just dealing with the accessory liability claims, the dishonest assistance and knowing receipt, they are a powerful part of a common law court's armoury against fraudsters. Those accessory liabilities claims do matter. They are important in the fight against fraud, because they add something that a technical constructive trust claim, proprietary claim wouldn't cover. They do exist as a part of the DIFC law of equity and trusts, and I just want to pick that in a couple of places. First of all, in the Carmel case, which was the jurisdiction challenge, there was an argument about whether or not the DRC court had jurisdiction to hear the claims, and that was a case that involved claims for both dishonest assistance and knowing receipt, and that's in your bonded at 7560. So if we pick this up in the middle of 750, it just gives a list of.
I'm sorry, you'll have to wait.
I'm so
Lots
sorry.
of circles going round and round and not getting there.
Okay, no problem.
I'll try again. Doesn't seem to like 7560. What's it called? I'll go down the index and get it. What's it called again?
It was called sorry, I'm so sorry. Can you just give me a moment? Mine is just frozen for a second. So this is the Carmel case, CAAMIL. It's a decision of Justice, His Excellency Justice Al-Madani.
Yes, okay, I've got it now.
Grateful.
Carmel.
And this was a jurisdiction challenge. And at page 7560, it lists the causes of action. And in particular, at Roman 11, there is the duty to account as constructive trustee on the grounds of knowing receipt and or dishonest assistance.
Yes.
So that was one of the claims, and slightly regrettably, in my version, the text has been overwritten a bit. But I'll just read out the next paragraph. It says, I think, as noted several times above, on C's case, the trust and fiduciary duties are said to have arisen from the contracts. With this in mind, and applying the ruling at 82 of Carafi, in my view, it's clear that the above listed claims to remedies that C has a good arguable case that the court has jurisdiction to hear and determine each of her claims against the defendants pursuant to Article 5A of the JAL. Either claim either arises out of or instead relates to the contracts being the contracts, at least supposed to be performed within the DIFC pursuant to express or an implied terms stipulated in the contracts. So the judge there is considering the question of whether there's a good arguable case that the DIFC court has jurisdiction to hear those claims. And he notes that each claim either arises out of or instead relates to these contracts. And he at no point does he say, actually, these are not causes of action known to DIFC law.
Do we know if that was argued?
It was. I don't believe it was, my lord, from my reading of the judgment. Then there's the point about your lordship alighted on Article 11 of the trust law, and this was considered in the DIFC authority decision.
Where's that?
That is at 7155 of the bundle. Now, I don't know if your lordship has come across this case before, but essentially it was an application for the interpretation of parts of the law. Various issues had come up, and the court's guidance was sought on different laws and how they might work. And there were a number of different parties who were appointed in order to argue the points fully. And in particular, one of the questions was raised about Article 10 of the Trust Law, which leads into Article 11, about how the law of the DIFC law of trust and equity worked. And if we pick that up at paragraph 139, which appears at 7. Sorry, actually, we might just go back and look at the. Yeah, if we get if we go back to 7175, the question was whether the reference in Article 10 of the Trust Law to the common law of trust and principles of equity includes the common law of trust and principles of equity. It's understood under the law of England and Wales, and then is limited to that. And if we just then look at the reasoning at 139, if your lordship could just read 139 to 143, please.
Yeah.
So there's some Delphic elements to this answer in terms of the direction of the law, but the way that we understand, just picking up at 141 at the end, the court itself therefore has the authority to develop the common law of trust and principles of equity in the same way that other common law courts might do on a case-by-case basis. And then it goes on to say, is not confined to the application of common law trust and principles of equity as understood under the law of England and Wales. So the DIFC court does have certainly quite a high degree of flexibility. It's to be exercised on a case-by-case basis. The court isn't constrained by English law. Now, my learned friend's argument was that it was fine for this court to apply the principles of equity, but what it couldn't do is create causes of action that weren't expressly listed in statute, and we just don't see why that's right. It's quite clear from this that this is a broad power and authority, and these accessory liability claims are, as I've said, a very important part of the court's armoury in the fight against fraud, and there is no reason why the DIFC's armoury should be more limited than other common law courts. Now, in my skeleton argument, I also we've obviously given you quite a lot of detail on the various routes through the law that these causes of action could be invoked under. And I still very much rely on what I say in my skeleton, but I don't need to just recite what I've said there. Your lordship hopefully has those points. My lord, if I've said enough on accessory liability, can I move on to deal with the misfeasance point?
Yeah.
So we say it would be remarkable if there was no misfeasance claim on the DIFC insolvency law, when the equivalent regime under English law is a very important and powerful part of the armoury available, not just against directors, but also against misfeasant offices, including office holders. My learned friend's, I think, main point was that the provision under the insolvency law in the DIFC is remedial in nature, and as a result doesn't give rise to a cause of action. But that's a bad point, because exactly the same regime in England also appears under essentially a remedial heading. And we can just look at that. If we look at the DIFC law, the 2009 law, that's at 3710.
Yeah.
And the cause of action that we rely on there is Article 80, which is entitled Summary Remedy Against Delinquent Directors, Liquidators. And then if you look at the equivalent English regime in section 212 of the Insolvency Act, that's page 2508. And that has exactly the same heading and status. It's identical. Summary remedy against delinquent directors, liquidators, etc. Now, admittedly, if we just go back to the DIFC law at 3710, the mechanics of it are different. Obviously, I recognise that. But my learned friend's argument seems to be that power within Article 80 is limited only to the exercise of the claims within 73 to 79. So her position is that you cannot bring a misfeasance claim under DIFC insolvency law. And she says that because she says it's a remedy provision. But that, in our submission, is simply wrong, because, as I say, the English section 212 behaves in exactly the same way and is a freestanding misfeasance claim.
But what is the essence of the misfeasance that falls outside any of the provisions in 73 to 79?
So for example, you can bring a fraudulent breach of duty claim. So as you could under section, it's exactly the same under section 212. You can bring a claim against an officer for breaching their duty to the company.
But I'm how does this assist? How does it add anything? Whether you bring the claim, whether you bring the claim,
that's a separate point. But I would need to reflect on that. I mean, this is a separate cause of action that we have pleaded, that we are entitled to pursue, and that gives us access to this regime for awarding loss. And that may not be identical to the way that a court would approach damages under the common law, because there is a broader range of remedies here. So I'd like to reserve my position until later in these proceedings as to whether I actually say on the pounds, shillings and pence in this case, it makes a difference as to how I would quantify loss. But it is a separate cause of action which I'm entitled to pursue. And there is the potential that it might lead to slightly different outcomes.
Well, I'm just looking at 80 A, B, C, D.
Yes.
The only potential difference here is likely to be as to whether or not there is, quote, compensation that might be different from damages.
Yes, exactly. And but there might be. I mean, that's not an unreal point in these sorts of misappropriation of business cases, because there is a question about how you how do you calculate the loss? To what extent is the fraudulent recipient entitled to account for the profits that they have subsequently received from the misappropriated business? Do they have to give those up, or is loss calculated at the point of transaction? There will be issues there. So,
but that would only apply to BJSSAM in terms of its profits. The individual directors or individual defendants won't have got anything except their salaries.
Well, that remains to be seen what exactly they got.
All right, but just to avert to the wording of 80, what do you say the words "a person to whom this Article 80 applies" means?
So, well, let's just look. If we just look, well, we would certainly say that it applies. If we go back to Section 212, we would certainly say that it applies to officers of the company.
But do you find that where do you find that in this statute? And this statute, protection of assets and liquidation, we're looking at.
Yes.
Part 5.
Yes.
Article 80 shall apply in respect of any person being a past or present officer of the company who has done something in Section 73.
Yes.
And then each of the others refers to the Article 80 applying to officers, etc. But it's very specific about to whom Article 80 is to apply.
But sorry, the submission I'm making though is that although it will subsume the compensation regime that's available to those causes of action at 73 to 79, it is not limited to them in exactly the way that Section 212 is not limited. And your lordship says, well, where can I see as to who it's designed to hit? Well, you can see that from the title. It's a summary remedy against delinquent directors and also liquidators. And you don't see that in any of, particularly the liquidator point, in any of 73 to 79. So we say this is a classic misfeasance regime that you find in insolvency legislation that allows the insolvency court to hold directors and liquidators to account.
Yeah.
And a liquidator isn't, I believe, even mentioned in any of 73 to 79.
No, well, that's simply telling you who can apply for the remedies in question.
No, my lord, though, it's a summary remedy. Sorry, the heading is summary remedy against delinquent directors, liquidators.
Oh, I see. I've got you. Yeah.
Yes.
Okay.
So my
it
point
applies
is
against the liquidator as well. Yeah.
Yes, it implies against office holders as well, and we say that is a classic application of an insolvency regime that gives the court broad misfeasance powers against officers and office holders.
Yeah. All right.
So we say that these points about the causes of action not existing are just simply bad points, and you should resolve them against the defendants. So, my lord, I think those are my submissions on the 3 introductory points, unless I can assist you any further.
No, thank you. Ms. Martin.
Thank you, Your Honor. Just would like to briefly respond on the time bar. Mr. Shivji took you through a case called Paragon Finance,
Yes.
and we would say that the case does not stand for the proposition that Mr. Shivji cited it for. What the court was interpreting there is it was distinguishing between the conflict rule and the profit rule together versus negligence by a fiduciary or breach breach of the duty of care. And it doesn't say that the conflict or profit rule breach creates a fraud claim, or in any event, a claim that requires fraud as a necessary element. It basically just said that a negligence by a fiduciary is just negligence and not a breach of fiduciary duty. So it was separating out those sort of two categories of claims. We would say that that analysis is not applicable here. So on Article 62, I had of the trust law, the court had really essentially asked the same questions that I was asking in my mind of like whether or not it is intended to apply for all purposes. I didn't hear Mr. Shivji give any constraints to the circumstances in which it may be applied. Does it apply only within the confines of the trust law, or is he saying that it applies outside of the trust law? That part was unclear in his answer to me, and we would say that whatever its application, it needs at the very least to be constrained to the trust law, but that in any event, that if that's Mr. Shivji's position, he really needs to connect the dots both for us and for the court. In the Cunningham case, paragraph 95, I believe, is where Mr. Shivji took us to. And a key feature there is that fraudulent misrepresentation was the unlawful means in that case. So what this case doesn't stand for is the proposition that you can take a non-fraudulent claim, put fraud onto the beginning of it, and then use that as the basis for saying that an unlawful means conspiracy is a fraudulent unlawful means conspiracy. We run into sort of overlapping problems as between the time bar discussion and the existence or non-existence of certain claims in DIFC law, and that is whether or not by doing something like adding fraud to a statutory cause of action where fraud is not an essential element for purposes of statute of limitations, whether or not that would be impermissibly legislating from the bench. We say it would be both in both contexts. And then just back to the statutory language that Mr. Shivji anchored on in Article 38 of the, I'm sorry, Article 9.1 of the Law of Obligations. Which is page 3290. Excuse me, 3300. Where he's looking at the language and saying that it's different from the English language and therefore should be interpreted differently. I didn't hear a rational basis for giving the interpretation that he asked for. Where I read it, where it says where a cause of action arises as a result of fraud by the defendant, what I read that to mean is a cause of action that is provided for by DIFC statute, therefore giving rise to this court's jurisdiction, not a cause of action created by convenience for the claimant's purposes because it suits their pleading needs. So turning to the existence or non-existence of certain claims under DIFC law. First in the case, and I'm sorry, I didn't note the name, but the case that had the lists of causes of action in which the court asserted jurisdiction, I believe it's meaningful that the existence of that cause of action was not being contested at the time, and that the court should not take it as a given that this court has blessed causes of action that we say don't exist because they are not found in statute. Correct. So for that purpose, even though whether or not the statute exists or the cause of action exists in statute is a jurisdictional question that gives rise to the court's powers, and that's important. Analyzing whether or not the court undertaking that particular jurisdictional exercise of analyzing whether or not it could act on the facts pleaded in that case it's a different sort of exercise where, as we say, it does not appear to have been considered whether or not these claims existed. That was not a challenge raised by the defendants there. So we would say that the court should not rely on that case for that purpose. In the DIFC authority case, it talks a lot about adoption of common law principles. I didn't read anything in there to say that it gives the court authority to create substantive causes of action where they do not exist in statute. There was a sort of tangential point raised in there about who it would apply to, and the court raised that it wouldn't apply to the individual defendant, that these accessory liability claims or misfeasance claims would, excuse me, the accessory liability claims wouldn't apply to the individual defendants because they're not alleged to have profited from these activities. And we say that's right. Now, Mr. Shibji says that that is yet to be determined, but it's not an allegation in the particulars of claim. And if that's a fact that he wants to rely on, he needs to plead it. Now, Mr. Shibji makes a point of comparing the title of the 2008 insolvency law to the English insolvency law, which is summary remedy against delinquent directors, liquidators. And it may be noteworthy to the court that the insolvency law 2019 title changed it to just remedy. Again, making it even clearer that that is all that it is meant to be, and that the way that it gets enacted is by reference to the statutes preceding it. I believe it was the Camel case that I was referring to that had the list, and so my apologies.
No,
sorry.
I got that.
Okay. And we would maintain our position on Article 11 of the trust law. And I have one note from my colleague, if I might give it a read before I.
Sure.
Thank you. Just briefly speaking on the limitations issue on the insolvency statute, the claimants here are taking a slightly different position than they've taken in their pleadings in the past. Here I have reading from paragraph 24 of their skeleton on extension of time, and they state here that the claims under the insolvency law were only brought in the claim form in the alternative as a belt and braces measure, insofar as such claims have not been commenced by the liquidator's insolvency application notice of the same date. In any event, there is no suggestion that an extension of time for the claim form will deprive the defendants of a limitation defense in relation to those claims. We have, of course, pleaded contrary to that. We would say that we preserved our position on that, and that if the court is inclined to take it up, that at the very least, there shouldn't be a waiver argument against it. Based on that, those are my submissions on those three topics.
All right. Thank you. Now, where do you want to go next? Are you looking for some indication from me in relation to those matters?
If the court would find it helpful, but if not, I'm happy to just move on with the bulk of our submissions.
Well, subject to further reflection, because I may, of course, have further and better thoughts. I can't see any basis for striking out anything on the footing of your submissions, save possibly for the claim that's based on Article 80 and the summary remedy against delinquent directors, liquidators. At first blush, it seems to me that there's a case for saying that Section 80 can only apply to Section 73 through to 79, or Articles 73 through to 79. In every other respect, it seems to me there's plainly room for argument about the principles of law which are applicable and which it would not be appropriate to reach a decision in the context of a strikeout or a summary judgment application. So I'm against you, Miss Martin, on relation to your application in every particular so far, except potentially the Section 80, Article 80 point.
Well noted. Thank you very much.
Now, we're now 2 hours in. I was thinking we might take a 5-minute break at that point, if that was convenient, and that may help you to think about where you want to go next, or you may already have decided that.
I'd be grateful for the 5 minutes.
All right, we'll take 5 minutes then. Thank you very much. All right, when you're ready, Miss Martin.
Thank you very much. I would actually just like to start with some of the principles and how they interact with the pleadings that have been put forward by the claimants. And I'll principally rely on our skeleton and so won't belabor them. But I just wanted to emphasize 5 points for the court's consideration, as well as to draw the court's attention to a couple of the cases that we cite. First is pleading fraud. Now, Lord Millett stated in Three Rivers quite concisely that fraud must be distinctly alleged and distinctly proved. And it is moreover described in the cases as a proportionate burden. The more serious the allegations, the higher the burden of pleading. And as explained in the Fiona Trust case, and this is at page 4199, just like the court to read along paragraphs 1438 and 1439.
This is all about cogency of proof and so on, is it?
Yes, and it is a burden of proof case, but we say that, hearkening back to what Lord Millett said about the burden of allegations, that it's the same burden.
Yeah. No, this is all familiar territory. Yeah.
Right.
Yeah.
So second, I would just like to talk about inferences. It is an understatement to say that the claimant's case relies heavily on inferences. Our submission on inferences is that fraud and dishonesty can be inferred, but they can only be inferred from facts. They cannot be inferred from other inferences. And this accords with the approach laid out in a DIFC case called SMB. That can be found at page 7604, paragraph 30.
Sorry, page again.
7604.
Thank you. Yeah, where am I looking?
Yeah, it's a bit of a long paragraph, but if you go about maybe 2/3 of the way down it, it says each fact from which, whether alone or in conjunction with other facts.
I'm sorry, I must be on the wrong page.
Paragraph 30. So there's a citation to Three Rivers, and then if you go down to the sentence that is 4 lines down, beginning 4 lines down from that, it says it is true that when giving particulars no more than.
I'm sorry, I must be on the wrong page altogether. Can you give me the page number again?
7604.
Oh, sorry. Yeah, my fault.
So
Yeah,
maybe a little more
parenthetic.
than halfway down. Yeah, a little more than halfway down the paragraph.
And what are we looking at here?
Yeah, a little more than halfway down, it picks up on this point that each fact from which, whether alone or in conjunction with other facts, an inference of fraud or dishonesty is sought to be drawn, must be pleaded, albeit the pleading of those primary facts may be done by way of summary rather than precise detail.
Yeah.
As Lord Millett said in Three Rivers, is not open to the court to infer dishonesty from facts which have not been pleaded. So this case, it speaks in terms of inferences that can be drawn from facts, but what it does not say it is willing to accept is a case built upon stacked inferences. Now, the particulars here use the term infer 56 separate times, which is more than once per page. But there are other lingual indicators of inferences, such as the liquidator understands, and then sometimes there are inferences that are just stated as if they are facts. This layering of inferences goes something like this. An inference of a dishonest scheme is set forth. A primary fact involving lawful action is pleaded, from which a primary fact of unlawful action is inferred, from which the particulars conclude that a breach of duty occurred, therefore substantiating the existence of the scheme, which in turn is then pleaded as tending to prove subsequent inferences. Now, some of the inferences themselves are perfectly lawful, such as we would say at paragraph 42 of the particulars. This is page 27 of the bundle, where it says it is inferred that Mr. Sassoon and Estruc suggested an end to the joint venture on behalf of BJSS. Now, we dispute sort of the timing that they lay out here, but it's perfectly lawful for them to suggest an end to the joint venture. Or in the subsequent paragraph 43, where it says that it is to be inferred that these options for ending of the joint venture were the subject of discussions between BJSS and ACCL between January and April 2014. Again, it infers lawful activity, but other of the inferences are just entirely misplaced. And here I would direct the court's attention to paragraph 40, which alleges that on 9 January 2014, Mr. Sassoon announced that he would resign as director of BSA upon a replacement director being appointed. Mr. Sassoon formally resigned on 18 February 2014, and it is to be inferred from the timing of his resignation that Mr. Sassoon resigned so that BJSS could take advantage of BSA's business opportunities in furtherance of the scheme. Now, my reading of that is that they say he resigned so that they could undertake activity that, frankly, they could undertake anyway. They could wind up this joint venture if they wanted to. They could start other businesses. BJSS can. It's neither here nor there whether Mr. Sassoon is sitting in the position of director or somebody else is sitting in that position of director. They were always going to have 3 directors there. So, I mean, a couple of questions in this regard. That first, what are the business opportunities of a company that is destined to be wound down because the shareholders are already discussing it? And again, why would Mr. Sassoon sitting in that office or not have anything to do with whether or not the bank would or could take advantage of those? For as long as BJSS was going to be a going concern, it was going to have 3 appointed directors. And so we just, it's frankly an incomprehensible inference, but it's clearly portrayed in a way that suggests some sort of dishonesty or misconduct. But the key inference I want the court to pay attention to is the inference that Mr. Sassoon shared BSA's confidential information with, I'm going to call it JSSME because that's its current name, but we can talk about it as BJSSAM if that's easier for the court. So that, it's an inference of, it's not even just an inference of dishonesty, it's an inference of primary fact. And so we'll see that it's the key without which the claimant's pleading does not work at all, unless true, but they've put forward nothing to substantiate it. And we'll get into detail on that later. But talking about the third principle of strikeout, that I'd like the court to pay attention to. And further leveraging this assumption that the court starts with, that people don't lightly act dishonestly. Well, it's not strictly necessary for the claimants to plead motives. Courts have suggested that where no motive can be ascertained, that can factor into a court's rejection of a claim. Here we cite the case Singularis, and this is on page 8331.
I'm sorry, what is the third point that you're actually making here in relation to the motive?
Sure. So the point is that where they have not pleaded motives, and they have not, other than I suppose is the court says that the fifth defendant had a profit motive, but that it was a commercial company. It was always going to have a profit motive. That's not dishonest in and of itself. But it doesn't plead any motives on behalf of any of the defendants. And
well, it does, doesn't it? That's the threefold purpose of the scheme that you've drawn attention to in your skeleton, I think. It's sometimes referred to as two purposes and sometimes three, but
well, I suppose I'm at a loss for what they are saying. I mean, as the court pointed out, they didn't say that the individual defendants stood to profit from this, that they stood to gain from it.
Well, but they are all part of, aren't they? The quote conspiracy as alleged, whereby the fourth defendant is to relaunch its business in the DIFC with BJSSM and is to deplete the assets of BSA and take them on board in the context of BJSSM, and thereby to shield the company from the contingent, likely, whatever debt you want to, adjective you want to give to the debt that's going to come by way of judgment for the Alcorafis.
Well,
and somewhere or other it's expressly pleaded, isn't it? What the purpose is, what the motivation is. And your focus at this point is on the individuals, is it?
Well, it is, but also as to the fourth defendant, BJSS, it had means of launching a business in the DIFC without resorting to dishonesty. So I mean, I suppose that they differentiated on the basis of the fact that there was this outstanding contingent liability, which again we don't accept. We say that there are other motivations for what happened as between the shareholders, but even if their point was to disadvantage the creditors of BSA, they would be disadvantaging themselves, and that's sort of a nonsensical motive for them, where they stood to be potentially jointly and severally liable with BSA. I mean, wouldn't the stronger motive to be to keep the assets in the company so that the company could pay the debt and the other shareholder could bear some of the burden? That would be a logical motive, and that is what we are saying here by referring to this case, is that by and large, dishonest people are dishonest for a reason, and so yeah, this is not resorting to it for fun, but where the motives are, if you look at them in the round and in reality and with real commercial incentives, it's just not what the claimants make it out to be. And so here I would ask the court to take account of minimal evidence, just of some extraordinary general meetings as to the other joint venture entities. Their purpose in winding up BSA was in winding up all of the BSA entities. And so we can see when those actions started from the evidence. And I would ask the court to go to page 1296 first. So here on 18 July 2013, which is really, I think, before they say this dishonest scheme began, the shareholders passed a resolution to commence pre-wind-up procedures at the Oman entity.
Yes.
Page 1298.
But aren't we just getting into fact here, William, Miss Martin?
minimal fact, which for the purposes of summary judgment, the principles do say that the court can take into account if they are facts that are unlikely to change at trial. These are facts that are unlikely to change at trial. These, I don't think that the claimants dispute that these shareholders meetings happened.
No.
And my impression is that they actually even plead that this was the purpose of the fourth defendant. So I would just like the court to have these dates in mind, because this sort of question of when gets really, really lost in the way that they've pleaded their case, because they haven't pleaded with particularity. So this resolution or gave an in-principle approval for the wind-up of BSA India. This was end of July 2013.
Yeah.
Quickly going to 1300.
Mm.
This is on the 5th of September 2013. The shareholders approved the voluntary liquidation of the Bahrain entity.
Yeah.
And then at 1451, it got separated from the others. On 26 June 2014, the shareholders of the Qatar entity resolved to set in motion the process to place the company into members' voluntary liquidation. So this was not a scheme that these defendants hatched and then surprised Mr. Walia with in January, which is the way it's pleaded in their case. This was a deliberate, iterative process of winding up all of the BSA joint ventures.
Yeah. I understand all of that, but one of the oddities about the way in which you constantly appear to run your case is to focus on Mr. Walia, who may be absolutely equally to blame or more to blame, but doesn't let your clients off the hook if the conspiracy is as alleged. On the face of it, you quote meetings where Mr. Walia was very keen to deplete the assets. So be it, but that doesn't seem to me to let you off the hook. Of course, it may help you on your credibility as to what you were doing and in your reaction to what he said, but I mean, it just seems to me one's getting straight into the factual questions here, and I'm not sure. Well, I can't answer factual questions at this stage.
We're not asking the court to answer any factual questions or conduct a mini trial on these. We're asking the court to take note of just a slight. Actually, it's a picture that is pleaded within their pleading. These are facts that support things that they say in their pleading.
Well, I have all of that on. I have all of that on board, Miss Martin. The points that you can make, but the question is, does this so destroy the foundation of what is being said, which starts off with business that is in BSA and finishes up with business in BJSSAM? That's the fundamental fact. And the question is, did it get there legitimately or illegitimately? And was there a conspiracy to get the business there and to deprive the potential creditors?
Well, if I could ask the court respectfully to just walk back, assuming that it's a fact that BSA's business ended up at BJSSAM. I understand that that's the allegation, but
there's no question at the end of the day that a whole bunch of clients of BSA finish up with BJSSAM. That's an admitted fact, isn't it? 200, is it? 133, 233. I don't have the numbers to hand, but it's that sort of figure.
We've attempted to run the numbers, and given we're working with 10-year-old data, it is a challenging exercise to try and get.
I'm sure it is. I'm sure it is.
Adequate numbers.
And on the face of what I've seen, we have Mr. Walia who's trying to do much the same thing to get them to his company. Understood that. The evidence appears to show that the shareholders thought this was an appropriate way of going on.
Well, but of course, the clients had a say-so in all this. There are some clients who, on terminating their relationship with BSA or having it terminated by BSA, did choose to open an account at BJSSAM. But there are many who did not. And I
Sure. I understand all of that. That there are real factual issues here. Don't get me wrong. I understand that there is room for considerable debate as to what the factual position was and whether there was a procuring of people to go to BJSSAM. But there's enough there to show that that was certainly encouraged. Letters were produced that standard form letters, terminate your agreement with the BSA and go to BJSSAM. That what I struggle with, Miss Martin, and I'll just say it to you, and then I'll try and keep quiet. but there's a fundamental fact. I know you have a problem with property assets business, but the reality is that however you describe it, a contractual relationship with BSA is ultimately replaced in a number of occasions with a contractual relationship with BJSSAM. And that's the basis upon which it's alleged that business was and assets were depleted and the creditors are prejudiced.
I take the court's point, but I would also say that that is not on our reading what is articulated in the particulars of claim. I don't. We had this discussion, I believe, once where whether or not the allegation was an inducement for clients to breach their contracts, and there is no inducement for breach of contract claim being levied against any of the defendants here. So putting it in that way, maybe it's helpful to the claimants. Maybe they want to go reformulate their claims on the basis of it. I don't know. I haven't thought about it. I just know that it's not what we're contending with here. So what I do want to focus on is the particularity point. And we cite, of course, RDC 1743 for the rule that a party must specifically set out full and specific details of any allegations of fraud, dishonesty, malice, or illegality, and details of any misrepresentation.
Yeah.
So, and we say the particularity requires who, what, and when. So in contrast to the standard, the claimants rely heavily on this very generalized passive voice pleading, which obscures the who, what, when of their narrative. So just looking at the who, they use the term transfer, including transferred or transferring 66 times, and the use of the subjunctive phrase being transferred, and not 15 times rather, and on not one of those occasions do they say who or what did the transferring. Was it their own client? Did BSA do the transferring? It's not alleged to be any of the defendants. It's sort of like the transferring just happened. As to the what, the same is true of the term business, as the court rightly points out. They alternately say that the assets and the property and the business were the thing being transferred without defining any of the terms or saying how they interrelate, which to us is stunning because they use the term business 143 times. Now, they do, in paragraph 10, describe the client relationships as the essence of the business, but again, they don't plead how client relationships relate to the well-understood concepts of assets or property. Of course, we'll get into that in greater detail, but just to bottom out our points on the pleading standards. As to the when, the claimants have given themselves the maximum flexibility on the when element. When was BSA likely to become insolvent? In paragraph 28, it was July 2013. In paragraph 93, it was June 2014, and in the very next paragraph, it was April 2014. So when was it not? It was conspicuously not, according to their pleadings, when the liability judgment was actually handed down in August 2014, or later when the quantum judgment was handed down, because that would be too late to serve their narrative. Another when question is, when did BJSS begin to receive BSA information on performance, including RM performance? So if we look at paragraph 38, from their pleading, it says from around November 2013, Mr. Cartone began emailing financial information regarding BSA to Mr. Sassoon. But that beginning in is misleading, pleading artifice that ignores BJSS's receipt of such information before Mr. Cartone became CEO. And finally, if we look at when Alpen is alleged to have learned of the intention to wind down BSA, going back to this point of when Mr. Walia found out, and I'm not focusing on him, he was the other shareholder, and they sort of plead that he got surprised by this. Paragraph 42 suggests that it was at a meeting held in early 2014, which feeds the narrative that the defendants hatched a secret, fraudulent scheme to bring BSA to an end, planned it throughout 2013, and then sprung it on Alpen in early 2014. But the EGM records that I briefly took the court to are clear evidence that is unlikely to change with disclosure, which say that the resolutions agreed by both shareholders to wind up BSA entities began to be voted on in July 2013, suggesting that these discussions started before then. And so this ties back to the inferences point. The inferences ask the court to connect the dots, and how the particulars plead the when element asks the court to connect them in a certain order. But dots connected in one order form an entirely different picture than if connected in a different order. And that's why we say this when element in particular and the other particulars matter. The fifth and final point on the pleading standards that I wanted to make is on the limited evidence that we do ask the court to take into account on a few points. And so here we are not asking the court to conduct a mini trial or any conclusive fact finding. Rather, we're asking the court to determine if the particulars merits having all inferences pleaded accepted as true, or as being accepted as capable of sustaining the narrative that it weaves. Where we have the evidence itself and have been able to compare it to what is pleaded, far too frequently that the evidence does not say what the particulars say it says. And so just to cite to another court that was willing to take this approach, we cite the case Portland Stone, and this can be found at the hearing bundle at 6683, paragraph 76. So I start by reminding myself that I am not conducting a mini trial and am in a position to make findings about disputed fact. Instead, what I am concerned to resolve is whether the primary facts that the claimants have pleaded are capable of sustaining the allegations of dishonesty that the claimants now wish to plead in accordance with the principles that I've summarized previously. To that end, I've set out in some detail both A, the representations that are alleged to have been made, and B, the primary facts that are said to give rise to the inferences that representations were knowingly false on 16 July 2010. So in terms of the evidence that we will ask the court to take under consideration, in addition to these EGMs, BSA's constitutional documents and what its makeup was, because those define what the roles of the directors were and the roles, duties, and any limitations. And second is we'd like to ask the court to take a look at the particulars use of one particular client, United Arab Shipping Company, as the sole exemplar that was the subject of their ostensible transfer thesis. So this is at the particulars paragraph 78.3 through 78.4, which can be found at paragraph 30, or I'm sorry, page 37 of the bundle, or 36 rather, at the bottom. Now, bear in mind, this is after the shareholder wind-up vote. And so letters have gone out to clients saying your BSA account has been terminated, and United Arab Shipping Company gets in touch and says, please tell us additional details about what's going on. And they end up having a meeting that does not include Mr. Carton, just to be clear. But the claimants portrayal of the series of events, they don't plead what happens after, and it sort of leaves the impression, we would say, that United Arab Shipping Company, in fact, signed BJSSAM's additional general business conditions and became a customer, and therefore is representative of their transfer thesis. But this did not happen. This particular client declined to become a client of BJSSAM, and so the claimant's exemplar of one of transfer instead has the opposite effect of disproving their transfer thesis and demonstrating client autonomy. And the third sort of discrete category of evidence that we would just ask the court to take note of is facts that we know that were available to them, but that they chose to either ignore during the investigation or the drafting of the particulars. And one example in particular is the claimants being aware from the investigation that they did that a gentleman called Roy Clinton did the hiring at BJSSAM. And here, the reason we know this is because it was included in a questionnaire that he sent out to BJSSAM and included in an answer. So on page 1715. Sorry, 1718, I'm told. If we get to question 4, sub 9, you sort of have to read the preamble at 4. It's already quite loaded language at this point, right? They liked them and wrote to them and say, you headhunted these people. That's, that's not presenting the facts of hiring.
I'm terribly sorry. This document is what?
So this is an investigation questionnaire that the liquidator sent out in
that's what
2020, or it might have been late 2019, but in any event, I believe he received it back in 2020. And so because the management at BJSSAM it consists of the Bank of Singapore team, they actually really don't have very much information. And so you'll see that repeated throughout many of their answers. But what they are able to communicate on sub question 9 under question 4 is that the 3 RMs that they mentioned in their question dealt with Roy Clinton, who was a former BJSSAM director, who has since retired, but that's who they dealt with during their recruitment process. Now, we say that they excluded this fact from their particulars because it doesn't help their narrative that Mr. Sassoon was really some sort of puppet master here, controlling the information, controlling hiring processes, and thereby directing the fraud. This gives independence to those conversations and decisions of the BSA directors or former directors that doesn't help them. And so we would just ask the court to, again, have that in mind when it's considering whether or not the inferences that they ask the court to draw merit being drawn.
So this document is one of a number of questionnaires, I think, that's referred to in the evidence from Mr. Devenish. Am I to understand what we've got is questions which are being raised by the liquidator on the left and responses from BJSSAM on the right?
Correct. That's correct.
So the evidence that you're relying on is what BJSSAM said to the liquidator. Is that right?
Correct. And just the fact of the liquidator's knowledge that this gentleman, Roy Clinton, did the hiring, and we don't know what, if any, follow-up they did on this point.
Yeah.
But we know that they didn't include it in their particulars, and we think that's problematic because we would say that skews the narrative.
Yeah. Yes. All right.
In any event, it sort of leaves the mind to fill in the blanks that they left when they don't talk about who did the hiring at BJSSAM.
The only direct evidence that you've adduced is in the form of these questionnaires, is it? Which comes from BJSSAM.
in terms of that direct evidence of.
I appreciate that when you're bringing a strikeout application and summary judgment application, as soon as you get into factual issues, you've got a problem, and therefore there's no. You may be cautious about what evidence you adduce, but we don't have any evidence from any individual defendant here. We have Mr. Devonish producing a few documents, some of which are BSA, AGM general meetings, and we have questionnaires where the answers have been supplied by BJSSAM. So it's not a case where I'm presented with overwhelming evidence to show that the allegations that are being made are false.
No, and I think that would fail on either strikeout or summary judgment if we were to try it that way.
I understand that, and that was why I qualified what I said at the outset. But the question is, just how far does any of this take me? The answer is not very far, really.
Okay. Well, it's all a bit of a preamble for this the lens that I'm going to ask the court to use as we talk about other topics. Is that fair?
You carry on.
I mean, just because we're on the topic of BJSSAM hiring, I would have the court turn to page 1352. Which is an email from Mr. Kapoor, who's one of the people that the liquidator asked about in his questionnaire, and it is to Roy Clinton, and it makes clear that they are in discussions regarding potentially joining BJSSAM, and it is Mr. Kapoor who volunteers his salary information. We would consider this to be a very standard part of any hiring process. The response to the question of what are your salary expectations, you generally tell them what you make now, that you want to make a little bit more, and why, right? So that's what he does here. This is now Mr. Shivji's response to this is well, it doesn't mean that this information wasn't also provided by Mr. Sassoon, but of course there's no direct evidence of that information being provided by Mr. Sassoon. And so again, where that fact is the inference that they're asking for, we would ask the court to rely on the sort of indisputable facts before it. I don't think anybody would doubt the authenticity of this email.
But I thought there were specific, I've seen schedules of RM's salaries, performance, which were sent to BJSSAM.
Correct, but
by I think Mr. Sassoon's secretary, if I've got it right.
Very good memory. And there are also schedules showing that the very similar or the exact same information was sent in prior years right around the same time, because that's the time that everyone's discussing finances and closing out the year, bonuses, salary, all of which had to get approved at BJSSAM. And so they had to know what these figures were for. And so sending those spreadsheets at that time is entirely consistent with past practice. And allow me to correct, I believe the court said that they were sent to BJSSAM. They were not. They were sent to BJSS, which is sat in Switzerland, which is where Mr. Sassoon sits. His secretary is there as well. There's no evidence of those schedules or any of that information making its way into BJSSAM through Mr. Sassoon. There's only the request for an inference on that front. So if I misspoke or...
Well, I may have misunderstood the documents, but I had understood it went to BJSS and then on to BJSAM, but I may have that wrong.
That's the allegation. That is what is pleaded. But if I could take the court to the documents, maybe that would help clear up any of the confusion.
If you want to do that, do. Yeah.
Give me just a minute to get some page numbers. And if I could, we have examples in 2011. If we could start with.
The ones I had in mind, Miss Martin, were those which were referred to in HIDA 4.
Apologies, I'm sure I have this somewhere in my outline, and it's not currently in front of me, so I just need my team to orient themselves here.
But come back to it if you want, when someone's had a chance to find it for you.
Okay.
Let's carry on, and you can come back to that point if
Right.
it matters. I may have misunderstood the documents.
Well, I have them. I have one here, and so this is the one for sake of comparison to what is pleaded in the particulars of claim, and this is page 1184. So at this point, this is an email coming from Samina Ahmed, who is an Alpen employee of Sarasin-Alpen. At this point, Rohit Walia was still the CEO, and this is an email sending on information to a BJSS appointed director and a member of their HR team, as I understand the rules. Sending it on for bonus submissions for 2012 because they need approval for those numbers. So there's an explanatory email up front, and then if the court scrolls through for the next, I don't know, 2-3 pages, you can see that it includes RM names, it includes RM compensation, it includes bonuses. There's a whole explanation of how much of it is a deferred bonus versus not. There's some explanation around the jurisdictions in which they're required to give raises versus not. It's very specific. So this is information making it to BJSS through its directors so that it can be included in the compensation approval process. And just to correct one thing I said, that the provision to BJSS of that last lot of documents was directly through HR. It wasn't through the directors. That Mr. Schrodinger is an HR representative. So we are trying to locate the ones that the bundle reference for the ones that are included in the particulars of claim. We'll come back to it. But once we pull them up, one feature of the particulars of claim that relates to, that we say relates to those documents is that very shortly thereafter, there were 2 shareholders meetings had in January and February. Those are alleged in the particulars paragraph 42. And here, this is where they plead that it is inferred that Mr. Sassoon and S. Cooke suggested to end the joint venture on behalf of BJSS, and that this proposal was resisted by Mr. Walia and Mr. Kerman. We find this to be a bit of an odd suggestion when there were already so many joint venture windups in process. There may have been some disagreements as to how they should take it forward, but it seems to be almost at least evidence of unanimous agreement between the shareholders that windup should take place by that point. And just briefly before we move on to the unparticularized scheme, I did want to touch briefly on the liquidator's powers of investigation because we had that questionnaire response to it. He has extraordinary access to documents and information through his investigative powers. And so we would cite Article 96 of the 2009 Insolvency Law, which says that the court may order any person involved with the company to produce it or to the office holder an account of his dealings with the company or any books, papers, or records in his possession relating to the company or to any such dealings. He is not a typical claimant in that regard. And so where we point out pleading deficiencies, we don't consider it to be an answer that, well, we just need to wait to see how the case plays out or we need to wait for disclosure. The liquidator had years and years of opportunity and the court powers behind him to procure these documents and information. All right, I have a page number for the court's consideration. So page 1320. There's information, well, 1320 to 1331 are the emails that the court recalls. So if the court's through reviewing those, what we would say is there is no evidence of fact. There's only an inference that this information then just got forwarded on to BJSSAM. And so when you pair that inference that they ask for with the omission to plead the fact that Roy Clinton did perform the hiring on behalf of this organization, we would ask the court to be very, very careful about accepting that inference because we just do not believe that it is merited. But going back to the liquidator's powers, documents already in the hands of a claimant is a factor that courts have taken into consideration in cases that we've come across when considering a summary judgment application. The case we would cite for this proposition is Portland Stone. And at page 6669, paragraph 28. So for our relevant purposes, we sort of start in the middle where it says, in the present case, the defendants have given disclosure based upon wide-ranging search terms relating to multiple custodians, and although the claimants submit that the defendant's disclosure is not complete, they have not identified any specific omissions or areas of default that would justify the court in treating the claimants as if they were still materially excluded from access to relevant disclosure for present purposes. Now, obviously, this isn't an insolvency case, and so it's slightly different situation, but what we would say is that it would be one thing if the claimants were coming here and saying that they needed broad discovery and access to information to plead their fraud claims because fraud is sort of inherently secretive, had they conducted a thorough investigation. But as we saw at the last hearing, there were years-long gaps in the investigation, and from what we've seen, a real failure to follow up on prior emails that he sent, and I believe a complete failure to seek any assistance from the court if he believes that he was being denied information. I'm not aware of anything on the court docket where he sought the court's compulsory powers. And so it's no answer to the deficiencies in this particulars of claim that he doesn't have access to information because this is a fraud claim. So turning now to the unparticularized scheme to transfer assets or property, it is of course the organizing principle of the particulars. And the terminology is critical here because the insolvency law claims in particular require the claimants to identify as an element of the claim a transaction, assets, and or property. And for the very first time in their skeleton, with this case having been on for a year and having been discussed between the parties for a year before that, they claim on the back of the court suggestion that the asset at issue is BSA's goodwill. So if you use the PDF search function in the particulars, the term does not appear once. And so this is a significant departure from what the particulars actually say. They are replete with references to transferring clients. Starting with paragraph 48 through the 60s, the particulars mention a transfer of clients no less than a dozen times. And then we get to paragraph 68, and it talks about transferring RMs. This is also the thesis that they led in their evidence. So while the goodwill thesis at least sort of invokes the concept of an asset as an intangible asset, we would say it still does not work here on the very basis of the case that they rely on. So they rely on a case called Commissioners of Inland Revenue v. Mueller. And the page citation for this is Herring Bundle 2072. So it's a case interpreting and applying revenue legislation, specifically the phrase locally situate out of the United Kingdom for the purposes of determining whether stamp duty applies to a transaction for the sale of a business conducted overseas. This case does not stand on the proposition that goodwill is property for all purposes. And indeed, a number of the lords expressly said that this was a question that they were not answering. So Lord Davy at 227, Lord Brampton at 230, and Lord Lindley at 234 through 235. So, and further, if one examines the comments made by Mueller at 2064 through, excuse me, let me get the actual page site here. I'll get that for the court in just a minute. But the comments about the concept of goodwill generally, it was made clear that goodwill is not its own form of property that could be the subject of a persisting property or knowing receipt claim, or a shows in possession or a shows in action that is alienable. The passage relied on by the claimants is at 224. Which is I believe page 2071 of the bundle. And it shows that goodwill is not a thing that can be dissected or alienated separately from other components that make up a business, i.e. trademarks, business premises, personal reputation of employees, protected through things such as restrictive covenants. And we would direct the court to the sort of second half of the page in the paragraph that begins, yeah, page 2071, the paragraph that begins, for my part, I think that if there is one attribute common to all cases of goodwill, it is the attribute of locality, for goodwill has no independent existence. It cannot subsist by itself. It must be attached to a business. These observations are parroted by Lord Davy at 227. Just 2074, and Lord Brampton. And I won't burden the court by reading them all into the record, but Lord Lindley as well on page 235 of the opinion.
I'm not quite sure where this point is going at present, Ms. Martin.
Well, we've complained now for in numerous hearings and numerous pleadings that they haven't particularized their claim of a fraudulent scheme to transfer assets or property. We've asked multiple times, what are these assets or property that are transferred? And assets and property, they're important concepts because they are actual elements of the insolvency law claims. So without pleading that element, they fail to plead the claim. And so we're like, well, you can't, not to be cheeky about it, but you can't say that your employees are your property. That gets in the way of, sort of human rights issues. And certainly your clients are not your property either. Those are not property that can be transferred. And so they need to identify the property, particularly for the company property claim. What the statute setting forth that remedy says is, as the process to enact it, you have to trace the property. And so they need to tell us what that is. And this sort of like generalized, like it's assets, it's property, it's a scheme, doesn't really work. So this is the first time that they've really told us what they say they mean. And they've cited a case saying that they can use it on that basis. And we say, as to this case, it doesn't stand for the proposition you say it stands for. And actually, we were able to locate a case that rebuts what they're asking the court to hold here is that goodwill can be property for the purposes of a knowing receipt claim or a company property claim. And so the case we cite is called Australian Career Party Institute Party Limited. And it can be found at page 8258 of the bundle.
Sorry, I don't have that page in my bundle. What was the page?
8258.
I don't have that. Are these the documents that were added this morning?
They were added yesterday.
So these would be added overnight?
Not overnight. They were added at some reasonable time in the evening.
And these are the documents that we objected to?
They are the documents that you objected to, yes. But they're rebuttal points, 2 points that you raised. So it's a little bit difficult to follow because the point, even though they won on it at the court of first instance, it was a point that was not really pressed at the Court of Appeals. So the easiest place to see what the ruling was, if you go near the top of the page, top of the opinion. And if you just go over to where it says held, which is page 8258, and then if you go down to the next page, there's a third point. The appeal succeeded in two respects. First, the primary judge was in error in granting relief against Sage. Second, the primary judge was in error in finding that ACI received AIF's national property in the form of goodwill and assets of Sage. So I can walk the court through the paragraphs that tie this together. The trial judge's holding on knowing receipt as including a goodwill claim is recorded at paragraph 33. And then the reasoning is quoted at paragraph 109. paragraph 450 in the quoted passage. And this holding appears to have followed from the plaintiff's statement of claim extracted at paragraph 42. I'm sorry for all the jumping around. This is the only way we've been able to weave it together.
Sorry, we're now at paragraph what? 40?
42. And B is knowing. And so what this does is it shows that they pleaded in very similar terms to the way that claimants have tried to tee up their pleading of transfer of business contention here. So the issues raised on appeal are summarized at paragraph 36 of the lead judgment by Justice Sackville, and paragraph 1 of the Chief Justice's concurrence.
Yes.
And it's just on the nose where it says issue 3 is that the primary judge erred in holding the receipt of a goodwill could form part of a valid knowing receipt claim.
Sorry, where's that?
This is page 8265, paragraph 36. It gives the preamble of the primary judge erred, and if you go down to Romanet 3.
Well, that's the contention. I'm looking for what the court says.
So the court's So there's a concession by the claimant at paragraph 125. That's on page 8282.
That's a finding of fact.
Correct. And so then the
How
court's
does that help?
Well, the court's reasons for upholding the appeal on the knowing receipt issue, even though the appellants failed on the other issues, including dishonest assistance and the challenge to breach of fiduciary duty and setting aside the primary judge's orders, are at paragraph 196. And this is on page 8296.
But are they saying you can't have such a claim in relation to the goodwill of a company?
We submit that they are. The Chief Justice's concurrence on this issue is recorded at paragraph 2. And another concurrence with the lead judgment is recorded at paragraph 29.
196 is simply the order made. I'm looking for a statement of some kind that this is not just a finding of fact, that on the facts there was no relevant transfer of goodwill.
I don't think that that's what's the question that was before the court, because the claimant conceded that it wasn't. The claimant conceded that they didn't receive property in the form of goodwill, and the judges said that's right.
But that's not saying you can't receive property in the form of goodwill. And goodwill is, you think of any number of sales of companies. When you sell a company, a price is often paid for goodwill. It's a fundamental. It's an asset. It's a very intangible asset, and it's one that is very difficult to value. And that's where negotiations are often found on sales.
Well, so if we look at the practicalities then of treating goodwill, which is an intangible asset, as property, it becomes very difficult. So one of the remedies the claimants seek is return of company property.
Yeah, well,
and what does that mean?
It's a nonsense. I mean, it isn't realistic, and I think I put that to Mr. Shivji earlier. What we're looking at is damages, and that all depends on evaluation of whatever the business was and its goodwill. You know, my instinct in this case is to say that the goodwill is probably not worth an enormous amount of money, but there it is. That would be a question for valuation experts. I have a horrible feeling that the costs in this case are going to far outweigh the amount of money that's ultimately at issue, even if the claimants are right. But that's life.
Well, we would, understanding where the court is coming from on that point, and it seems like the court understands the difficulties we're having with it being claimed as property.
I understand the difficulty in terms of putting a value on it. What I don't understand is why there's a difficulty in principle about saying the business of a company can be taken, its goodwill, and the benefit of contracts, which may well be terminated perfectly lawfully. But all the relationships that they have with relationship managers and with clients, you start off with a bunch of contracts that BSA has, which represent its business, and the form of remuneration they get comes from BJSSS by way of what's rather oddly referred to as a retrocession, but the business consists in the advice they give and their relationships with these various clients through relationship managers. And that's the very thing that BJSSAM has now got for itself, whether legitimately or illegitimately remains to be found out. But to say there's no value in the company itself and its business at a time before it was wound up, when it was making profits and so on and so forth, albeit much reduced as a result of the change of strategy on the part of BJSS under its new ownership. I mean, as a matter of principle, I don't see it. It seems to be perfectly clear it's capable of having some value.
I'm speaking to it specifically in terms of whether it is property for the purposes of a persisting property claim or knowing receipt claim, which is what they've pleaded. They haven't quite pleaded the contracts case that the court has put forward. And if that's the case that the new liquidator wishes to plead, then perhaps at the very least the court should give them the opportunity to plead a case more along those lines. But that's not quite the one they've brought. They don't mention the value of the contracts. This is the first mention they've ever made of goodwill. And we still have no idea what this property is. They say that it was transferred. No, contracts certainly can be, property in law, shows in action, and diverted corporate opportunities can be subject to an order to account or to lead to constructive trust over property rights that crystallize from the corporate opportunity. But the point is here that the claimants have not identified specifically or with the necessary precision any contracts or shows in action that were assigned or transferred by BSA or to defendants or anyone else, or any corporate opportunity that was diverted by the directors for their own or someone else's benefit. This gets down to director action and where they just ask for allegations in that regard and don't plead primary facts. So that is the point of the client transfer in the RM transfer section in the defendant's skeleton. We would say that the second claimant is a chartered accountant, and it took 2+ years plus a court suggestion for what the particulars should plead before the claimants finally explain their thesis in accounting terms that have any real relationship to the terminology he uses in the particulars. And that this level of wooliness just should not be accepted from anyone, really, but particularly a claimant who specializes in the use and understanding of these terms. So I just want to briefly touch on how this impacts on the insolvency claims, which the court, of course, already rightly said it's not clear to the court that there's any property there to be returned.
Well, I'm simply saying I don't see how you can return it. You know, they're now replaced by different contracts and so on and so forth. There's no relationship element that can be restored, is there? And that's the nature of you know, supposing your clients are taken away and go to someone else.
I believe that's right.
You can't get it back.
Yeah, it would. I think things that would be offensive to employment and other laws would have to be involved in order for that to happen. So I would agree. But under that reading, we would say that the transaction in fraud of creditors and claim for company property are both defeated because they both require property as an element.
Right.
And then just very briefly, a transaction at undervalue claim requires a transaction between the company, so in this case BSA, and another person within 2 years of the company's insolvency. And at undervalue. So because of these same pleading deficiencies, and kind of moving off the property point for a minute, but because of what the particulars say at this point in time, that they don't satisfy this first element of there being a transaction. We realize the transaction is broadly construed under English law, but even there, it requires that the insolvent party, or so that the company in insolvency rather, be a party to whatever transaction is identified and pleaded. So the transfer of business pleaded at the particulars at paragraphs 164 and 166, we would say suffer from a pleading deficiency in this regard, in that it provides no particulars of any transaction to which BSA was a party. As to fraudulent trading, just to bottom out the insolvency claim since we're here, the fraudulent trading requires the claimants to identify the trading of the company that was conducted to defraud creditors or for another fraudulent purpose. And the reason we mentioned in our skeleton that the way this claim typically works in practice is that fraudulent trading is generally used against directors to prohibit them from deceiving others to continue to extend the company credit, even when they know the company is insolvent and that the creditors have little chance of being repaid. That's sort of the classic case for fraudulent trading. And it at least gives an indication of how one would expect to see these elements fulfilled. Now, fraudulent intent as to the Al-Kharafis as a single creditor is insufficient to sustain a pleading. A fraudulent trading provision is not engaged in every case where an individual creditor has been defrauded. The section is engaged only where the business of the company has been carried on with an intent to defraud. And this is because individual creditors have their individual remedies under the general law, which here, of course, the Al-Kharafis tried to exact in 2016 and eventually settled. The case we would refer the court to here is in re Sarflax, and this can be found in the bundle.
That's not in doubt, is it? That's not in doubt. But what's being alleged here is the depletion of the company's assets to the detriment of all the creditors, of whom, of course, the most important is Al-Kharafi, which is why no doubt they're funding this whole exercise.
But the intent element, as they've pleaded it, was solely to disadvantage the Al-Kharafis. And according to Sarflax, the case that I'd like to take the court to, that doesn't work. So it merits some explanation as to the background.
Well, is that how it's pleaded? They talk about shielding the company from the effects of the forthcoming judgment. But what's complained about is the transfer of, quote, the business, the clients, the client relationship, however you want to put it, which results in the diminution of assets for the benefit of all creditors, which of course includes BJSS as it happens.
So in the Sarflax case, there was a similar sort of disparity between the allegation was that there was a transfer of assets to disadvantage a particular creditor.
Right.
I think as a conceptual matter, a transfer of assets that would put the company deeper in debt would tautologically disadvantage all creditors. So if the court follows the reasoning in Sarflax, where it says that the intent was to disadvantage a particular creditor, that's not sufficient to plead a fraudulent trading claim, then that would defeat the intent as pleaded here, just because the effect might have been general. So in Sarflax, the facts were that a supplier company was involved in litigation over a contract with a customer, and the contract involved supplying machinery. The litigation commenced in October 1971 because of issues with the functionality of machinery. The judgment was entered against the company in November 1973. Now, prior to litigation commencing, the company had ceased to trade in April 1971. And when the company ceased trading, certain assets were sold to the parent company to set off the indebtedness.
Yeah.
In September 1973, the company entered voluntary windup and liquidator was appointed. Liquidator brought claims for intent to defraud creditors based on transfers. Claims that were that the business had been carried on with an intent to defraud creditors, well knowing that the company was unable to pay its debts in full. Again, a very typical case. And the specific fraud alleged was the sale of assets to the parent company, and claimants alleged that this defrauded creditors by disposing of the assets. It found that such action was not fraudulent. The debt to the parent company was not contested, and thus the sale was merely paying debts to a creditor. Nothing in the statute prohibited a debtor from preferring one creditor over another in this case. But the court also discussed the expression carrying on any business. And here I refer to page 2341.
Yeah.
So it states that it's not necessarily synonymous with actively carrying on trade, which we know because it can just be taking on more debt.
So where are you on the page?
So at the very top, it says, I feel quite unable to say that the expression carrying on any business in this section is necessarily synonymous with actively carrying on trade, or that the collection of assets acquired in the course of business and the distribution of proceeds of those assets in the discharge of business liabilities cannot constitute the carrying on of any business for the purposes. So they're saying that you can interpret the carrying on of business more broadly than sort of the standard trading activity of the company, but the court rejected arguments that this is not appropriate for strikeout, given that the matter was extensively argued, and the court said it would be wholly inappropriate to decline to decide at the strikeout stage if it was able to form a clear conclusion on the arguments.
Yes.
So here, the main section rejecting it, and let me just make sure I have my citation right here. If I could just
The argument proceeded for 3 days. This is rather different, isn't it? I mean, this is payment of a debt, an undoubted debt, which is said to be fraudulent because the whole body of creditors and the extent of the indebtedness of the company is not fully known, even though it's likely to exceed the amount of the particular debt and payment to the individual debtor. Where's the passage that you rely on for the principle that you were putting forward? I see Sir John Chadwick was arguing on the case on one side, the losers. Go back to the head note. It's really a fraudulent preference case, isn't it? Without any fraud, because it was all said to be entirely bona fide. I'm looking at head note 2, page 2335. Which is why, even after 3 days of argument, Mr. Justice Oliver was prepared to say it was a plain and obvious case to strike out. I'm not sure which bit you really rely on, Miss Martin.
It appears I unintentionally hit mute. My apologies. If I could direct the court's attention to 8364, which is morphitis, I'm calling it. I'm not sure if that's the proper pronunciation. 3097.
Sorry, we're going to a different case now.
Different case. And at the bottom of note 47, this is where they state that an individual creditor who was defrauded in the course of carrying on of the business of the company has his individual remedy under the general law. That Section 213 of the 1986 Act is not engaged in every case where an individual creditor has been defrauded. The section is engaged only where the business of the company has been carried on with intent to defraud.
Yeah.
We do not read the particulars of claim here as alleging a generalized intent to defraud. The allegation that we see is that, as the court saw, that the intention was to deprive the Al-Kharafis of the ability to collect on their judgment debt. And just moving on to the paragraph under that, I would just read from that. And it says, in my view, it is impossible to reach the conclusion on the facts found by the judge in the present case that the business of the company was carried on after 12 November 1993, but not before, with intent to defraud creditors, or in particular, with intent to defraud a single creditor, Ramac. The business of the company was carried on, anyway, it goes on from there, but that's, if the court accepts this logic, then we would ask it to also submit that the facts advanced here cannot simply be shoehorned into a fraudulent trading claim under this insolvency law. On the basic case theories advanced in the present case pleading is difficult to see how a fraudulent trading claim could be properly brought if the claimants were given another opportunity to replead, given that they would have to express that BJSS would be willing to defraud itself in its trading activity. And for this reason, absent such an explanation, we believe that the fraudulent trading claim should be the subject of immediate judgment, not only strikeout.
But isn't paragraph 48 saying that it would be enough to carry on with intent to defraud a single creditor, Ramac? If you pleaded that, it seems to be saying it might be good enough, doesn't it?
I don't read that as what it's saying. I think it's saying that on the facts found.
On the facts, they couldn't reach the conclusion that the business had been carried on with intent to defraud creditors, or in particular, a particular creditor, Ramac. Mm-hmm. Implication, had they found that the business had been carried on with intent to defraud a particular creditor, that would be enough.
But I think that conclusion would be inconsistent with the paragraph immediately before it, which says that an individual creditor who is defrauded has...
No. An individual creditor is defrauded in the course of the carrying on of the business has an individual remedy. That's a different question. But if you carry on business with an intent to defraud creditors, or indeed a single creditor, not by the way you carry on the business, but the fact that you're carrying on the business. It's the difference between creditors defrauded in the course of the carrying on of the business itself. That's the distinction that's being drawn, isn't it? That's the way I read it for the moment.
All right. Well, we read it as saying that there needs to be an intent to defraud the creditors generally, or some other fraudulent intent. But that
what remedy would an individual creditor have who didn't have a fraud claim as such in relation to the cause of action? He simply has good claim, but in fact the business is bust and the intention is not to pay him, so it carries on business in those circumstances.
Given that this is an England and Wales case, my understanding is that there's a whole host of remedies available, many of which Mr. Shivji has cited back to, including misfeasance. This isn't just fraud. This is fraudulent trading under the insolvency statute, right? Yeah. It's a very particular claim that is meant for particular circumstances. And what this says is that the situation just doesn't fit those circumstances, that creditor has other remedies. Perhaps they can bring a misfeasance claim there. Perhaps they have other fraud remedies. I'm not as well versed on all the English statutes or common law causes of action, but I would assume that they had a host of remedies available to them. It just doesn't need to be this particular statute.
Well, the point that's being made, I think, earlier in paragraph 47 is that the liquidator has to bring the claim, not an individual creditor. That's the point, isn't it? You can't do this for the benefit of a individual creditor. Of course, it's for the benefit of the body of creditors, because it's the company's assets that are being depleted.
But I suppose this gets back to the distinction that we discussed earlier, where whether it's intention versus effect. If there's a purposeful deprivation of the assets of a company, wouldn't that, at least in a hypothetical sense, wouldn't that always impact on all creditors? And so where we have a court here saying that this particular statute is not engaged in every case where an individual creditor has been defrauded, then I think that we have to look at the intent element as pleaded, and you can't just rely on the effect in order to engage this statute.
But what was the claim in this case?
This was a fraudulent trading claim, as I recall.
I'm just looking at the head note and the first paragraph and the second half of it. What do you submit that saying?
The head notes in italics.
I'm just looking under page 3074.
Okay.
First paragraph of held dismissing the appeal, assuming that's an accurate summary of paragraphs 46 to 49, which it purports to be. The fraud appears to have been in the promise made to the landlord that they'd pay by in instalments, misleading him into believing that he wouldn't, his best interest would be in not taking proceedings. Then it goes on, it had not been shown that there was any intent to defraud the landlord by carrying on the business while the landlord was so misled, or that the carrying on of the business had defrauded the landlord. And so,
Yeah,
so the way I'm reading it, I think it is the way I was looking at whichever paragraph it was we were looking at before, 40 something, 47.
just one last very brief note on this, and
Yeah.
what we would say about that is that these cases are frequently discussed in circumstances where it is alleged that the business of the company was carried on for too long because it was already insolvent and they just traded it deeper into debt.
Sure.
That's obviously quite different from the allegations here, where they basically said, no, you wound the business up too early. You shouldn't have cut off its ability to make revenues in circumstances where there was live litigation. So again, it doesn't, the facts alleged here don't really fit the classic mold of this type of case, but I am conscious of time and happy to move on to the fiduciary duties discussion.
Okay.
So I just wanted to spend a note on the form of pleading, because as the court described it, it gets into the essence. I think from our perspective, it creates difficulty in tackling the fiduciary duty claims, because it's sort of well, if we can go to the particulars of claim, paragraphs 1 through 100 set out the party summary and facts, and so that's standard enough. But then we get into the causes of action starting at paragraph 101. Does the court have a paper copy of that, or does the court require?
I do. Okay. No, I have this.
So once we get to paragraphs 101, where the causes of action start, from 101 to 106, we see the sort of menu of duties. And then we start subdividing by individuals, taking Mr. Sassoon as an example. At 107 through 112, they plead alleged actions by him. And then 113 through 117 is a sort of one-size-fits-all breach of duty section regarding him. And then we see the same pattern repeated for Mr. Carton and Mr. Astruc. And actually, even some of the allegations in this cause of action section contain new factual allegations that aren't contained above. One example I would give is paragraph 135.7. Allegations regarding a report prepared by Deloitte that it just doesn't appear anywhere in the primary statement of facts. So it goes on in this manner, mentioning the scheme in almost every single paragraph, circularly using the scheme allegation as a basis to ask the court to infer unlawfulness. And we say that pleadings are meant to be intelligible, and it's very difficult for the defendants to disentangle which primary facts relate to which allegation, and we shouldn't have to do that work. At the very least, the claimant should be made to identify a single cause of action at a time and support allegations of its violation with relevant facts. But when looking at the breach of duty allegations, it is helpful to briefly remind ourselves of which ones are alleged to have been breached. So they do mention the duty of loyalty, I believe once in paragraph 105, but do not include any specific allegations in regard to the breach of loyalty per se. But of course, loyalty has two classic limbs, the no conflict and no profit. And the particulars allege a duty to account for profits, but I don't believe allege a breach of a duty to refrain from profiting as a result of a conflict. And the particulars, they do allege breach of duties to avoid conflicts. So the duty of confidentiality is alleged as against Mr. Sassoon and Astruc, I believe. In any event, it's alleged against at least some of the individual defendants. And then the duty of good faith and best interest is alleged against all. So what we don't see in the allegations is a breach of the duty of care, skill, and diligence, which in any event, the law says is sort of a separate type of duty. It's not really a fiduciary duty. The duty of care requires the holder of that duty to do certain affirmative things because he has a job to do and has to do it up to a certain standard. And this affirmative duty to act stands in contrast to other duties, and the distinction becomes important when looking at what is alleged here, particularly when what is alleged is an omission to do something that was, strictly speaking, outside of the fiduciary capacity. So talking about the best interest duty first. The particulars allege that a number of the factual allegations violate the duty to act in BSA's best interests. But for the legal discussion, the first principle I'd like to bring the court's attention to is the principle that fiduciary duties are generally considered to be proscriptive, not prescriptive. And for this proposition, I would turn the court's attention to a case called Howard at page 5537. So paragraph 31 begins at the bottom of that page and says the relationship of director and company is one of a class of accepted relationships which tract proscriptive fiduciary duties, including a duty not to obtain any unauthorized profit from the relationship and not to be in a position of conflict. These proscriptive duties attach to the powers and discretions exercised by the company directors. So there's actually a vigorous debate in Australia about whether fiduciary duties are ever prescriptive rather than proscriptive, with the majority view being that they are only ever proscriptive. And I'm not suggesting that the court needs to wade into that fray, but just simply ask the court to recognize as a guiding principle that fiduciary duties are generally considered sort of thou shalt nots rather than thou shalts. So the second principle is the coextensiveness of the duty with the role. And for that, we cite from the case Grimaldi at pages their pages, I'm sorry, it might be paragraphs 178 and 79, and on page 4298 of the bundle. I believe the court may have muted itself.
Sorry, yes, but what are you wanting me to look at then?
Okay, so I was giving the court time with paragraph 179 on page 4298.
Yeah.
Or I can read it into the record if it's more convenient. The concept of a duty and the conflict of duty and interest formula of the first of these is convenient shorthand. It refers simply to the function, to the responsibility the fiduciary has assumed or undertaken to perform, or on behalf of his or her fiduciary. What that function or responsibility is a question of fact. It may be narrow and circumscribed, as is often the case with specific agencies. It may be broad and general, as is characteristically the case with the functions of the company directors. Its scope may have been antecedently defined or determined. It may have been ordained by past practice. It may be left to the fiduciary's discretions to determine, and it may evolve over time, as is commonly the case with partnerships. Put shortly, the actual functions or responsibilities assumed determines the subject matter over which the fiduciary obligations extend. But the conflict duty and interest and conflict duty and of duty and duty purpose. As Lord Upjohn noted in Boardman versus Phipps, having defined the scope of those duties, one must see whether he has committed some breach thereof by placing himself within the scope and ambit of those duties in a position where his duty and interest may possibly conflict. It is only at this stage that any question of accountability arises. So the importance of this to us is this scoping exercise, because, for instance, the claimants suggest that for the BJSS appointed directors, or I guess either the shareholders appointed directors, to have had shareholder level discussions about the how to proceed with the windup it is itself a breach of those duties. And we say that that's really unworkable in a commercial context, and that's not what the law requires, and that absent some undertaking or some lack of disclosure, which clearly there was disclosure here. I mean, everybody knew who whose shareholders were who and who their employers were, that it's not a workable formulation of the conflict of interest duty in this jurisdiction. So, I mean, we have to kind of think about the fact that taking another's interests into consideration, it's hardly ever at large if you take on a fiduciary duty, but it's almost always an undertaking to act in another's interest in respect to certain things or in certain circumstances. I'm mindful of the time, so I don't want to take up a lot of time reading, but I would, if the court is interested in the subject, I would direct it to the Howard case at paragraph 34, which is page 5539 of the bundle. So one of the distinctions that this paragraph makes is it talks about the decisions they take as directors. And so we can sort of think about that as the difference between the maybe importation versus exportation. In that what it prohibits, being a prescriptive duty, is a director from importing into his carriage of his duties conflicts or personal or third party profit motives. It does not require the fiduciary to export into his life at large the duty to act in the best interest of the principal. And so when we say that duty does not coextend with every aspect of a fiduciary's life, that is easily demonstrated by some simple hypotheticals, and I'll use myself here as a fiduciary for Jones Day. So, would it be in Jones Day's best interest for me to clean out my savings account and give all my money to the firm? Now, yes. But is that what is required of me in my role as a fiduciary of this firm? Of course not. That's obviously quite an extreme example, but it's one that makes very clear the fallacy of construing the best interest duty as broader than coextensive with the scope of the action within the fiduciary's powers are exercised in the fiduciary role. So to make it a little more practical here, let's make this next setting a hypothetical JV. And so would it be in the best interest of the JV for its directors to hold no other employment and no other fiduciary roles? Well, you could potentially say that's the case, because what a great way to get single-minded loyalty. But is that what required of JV directors? And the answer is certainly not. It is the norm rather than the exception for JV directors to have commercial or operational roles that their respective employers. And is the norm rather than the exception for JV directors to have roles as directors, even at other entities frequently within the same sector. So is it those directors' duties to agitate proactively at every turn the interests of the JV within their respective employer, such as, hey, I want you to conduct a sale of this business, even if the employer says, no, we don't want to. That is what a proactive prescriptive duty to act would look like, and it would be incredibly disruptive for business, and make the director role sort of inherently disruptive. It's practically unworkable because there's no place to draw an outer boundary. And so the duty has to apply in a way that says when directors are acting within the outer boundary of the fiduciary duty, they are prescribed from doing anything that is not in the best interest of the principal. So should the court go down the path of legal precedent of prohibiting these arrangements or making them unworkable for employer-appointed JV directorships. And I would suggest that a ruling would be out of step with the balance of the common law, but particularly in this jurisdiction, it would render it uncompetitive, because the UAE, of course, is built on JVs because this country had oil money but needed subject matter experts to help it accomplish its development goals. And so imagine the message that it would send if this court were to say to the world, set up your JVs here, but shareholders don't expect to continue to act in your own interest without putting your appointed directors at significant risk of being accused of dishonest breaches. Now, defining the scope of a fiduciary role is, of course, a fact-dependent exercise. And we would rely on just the very limited facts here of the corporate constitutional documents to define it. And so what the uncontrovertible facts here say is that selling BSA was not in the scope of the directors or officers' fiduciary duties, as was ultra vires to the role. And this is in the shareholders agreement, articles 10.2G and 10.3B. Now, the claimants seem to recognize this because they say, no, they didn't have to complete a sale, they just had to procure one. But I ask how someone can have a duty to procure an action from a shareholder that the shareholder doesn't want to undertake. That is a shareholder reserve matter. That is a waste of time. It's a waste of money. It's a waste of resources, and we would say is an improper extension of the duty into a prescriptive role that just doesn't exist in other jurisdictions. So turning to the creditor's duty, which is a specialized aspect of the best interest duty in insolvency cases, the creditor's duty drives the question of when the best interest of best interest duty also has regard for the best interests of the body of creditors. This question was, of course, answered decisively by the English Supreme Court in Sequana in 2022. And that court held that the director's duty to act in the company's best interest must have regard for the interests of the body of creditors commencing only upon the insolvency, imminent insolvency, or likely insolvency of the company. We would encourage the court here to adopt the Sequana standard. The court there specifically rejected the creditor's duty becoming effective upon the real risk of insolvency, meaning the duty only bites when insolvency is likely on a balance of probabilities. So on this plain language alone, several of the allegations fail and should be stricken out. Paragraphs 28, 93.1, and 158.2 recite only a significant risk of insolvency and an awareness of this risk by two of the individual defendants following trial. But elsewhere, without any additional factual underpinning, the particulars plead a likelihood of insolvency. And we see this in paragraphs 94, including some of its subparagraphs, paragraph 104, paragraph 156, and paragraph 158. Now, these latter numbers are indicative that because they fall either within or very near to the causes of action, that they sort of molded their allegations in the causes of action to meet the legal standard instead of to the facts. So we wanted to give specific attention to the context of when do we see a likelihood of insolvency in the context of a pending legal action. And the claimants, we found actually no such case, and so, but the claimants found one case. We consider it factually distinguishable, and so I'm happy to take the court to that case, which is 7971. So here, the paragraphs that I would draw the court's attention to include paragraph 19, which makes clear that the company had already been teetering in and out of balance sheet insolvency for a number of years. This is on page 7978. Oh, sorry, 7971. And if you get to paragraph 52, which is 7978, it says, Additionally, the judge explicitly recognized that his adoption of the real risk standard, which he did there, had the potential to be inconsistent with Sequana, but he considered that case distinguishable from Sequana because the Sequana matter involved the possibility of insolvency, whereas the company under consideration there was, in the judge's view, actually insolvent based on the information at paragraph 19. Now, we consider this case further distinguishable in that it evaluates when a tax liability accrues. And so if the court here accepts the court's approach in Hunt, it would inflict a hindsight analysis every time there is a potential judgment debt or a litigation afoot that ends up going not in the favor of the company that ends up insolvent. And that is one of the things that Sequana specifically warned against. So we say that whereas here, defendants are in possession of advice that says that they have greater than 50% likelihood of success on the merits, that it's difficult to imagine a case where it would be appropriate to draw this line of Sequana prejudgment. Now, the particulars paragraphs citing the real risk of insolvency, not the others, are more supported by the contemporaneous evidence, which again is one of these bodies of evidence that is not likely to change following disclosure, and so we would ask the court to have regard for it. And this includes legal advice received in 2010 and 2013. So the 2010 risk assessment is at page 1049. We go to paragraph 4. And this says that it considers that BSA has a greater than 60% chance of success of defending the claimant's claim. If we go to page 1271, then we get to the 2013 legal opinion, which is preliminary post-trial assessment. So if you go to paragraph 8.1a, says that the risk assessment remains unchanged from that advised in April 2011 on that claim, which I believe is the advisory claim. Sorry. No, that's a regulatory claim, excuse me. So as cited by the claimants, paragraph 8.3e does revise the 2011 opinion to say that on the advisory issue, there is a real and substantial risk of an adverse finding. But a real risk, we would repeat, under Sequana is not a probability. And in any event, we would also refer the court to paragraph 8.3da, which says that even if the claimants were able to establish liability under any of their causes of action, they have a high hurdle to establish causation, i.e. that their losses were caused by the alleged misadvice. And the last piece of advice I would refer the court to, I won't take the court's time on this because I know we went through it last time, but it is the advice in the confidential bundle that we reviewed last time. And just for the court's reference, if it wants to refresh itself, page 1850.
Thank you.
So factors well outside of Mr. Walia's performance fed into the potential trial outcome, not the least of which was whether the Al-Kharafis were considered qualified investors. Other cited bases in the particulars do not support BSA's insolvency or probable insolvency. We would focus on the cited breach of the regulatory capital requirement as a complete red herring. This is not a situation where BSA was maintaining its regulatory capital by razor-thin margins, just the requirements changed and caused a breach that was quickly remedied at that time. So the reason the court drew the line where it did in Sequana is that in insolvency, the creditors become the economically interested parties. And here I would direct the court's attention to paragraph 57 of Sequana, which is at page 7737. Because I'm starting to lose my voice, if I could leave the court to read that without me reading it out.
Sorry, page number again.
It is 7737.
Which paragraphs do you want me to read?
Oh, just 57, where it talks about the sort of shifting of risks, I think is a useful exercise in understanding why they drew the line where they did.
Yeah. Yeah.
But so accepting the claimant's own pleading that there was a real risk of BSA's insolvency and Sequana hadn't been triggered during the relevant time, it's worth revisiting whose interests the BSA directors were meant to have regard for then. And the legal answer, of course, being the shareholders as a whole, but it seems that the claimants don't even really accept that, and they pleading that then the creditor duty arises if the directors know or ought to know that there is at least a real prospect of the challenge failing. We say that the effect of that would be that the claimants have to have adopt regard for the non-appointing shareholder, or at least that their directors do. And that, of course, is not the law, but even if it were, the liquidator would not have power or standing to bring a claim on ACCL's behalf. And so this brings us to the application of these principles in the way that they pleaded the scheme, which I've broken out into sort of 6 sections. So first is the formulation of the fraudulent scheme, for which they cite the relaunch plan email. So this alleges that the very drafting and sending, and in this case actually receiving of this email as the origin story of the scheme. Although if you look closely, the preparation and sending of the email itself is not alleged to be a breach of any particular duty. Rather, in paragraphs 108.2 and 119.2, the facts are sort of watered down to allege against Mr. Sassoon and Carton that they that furthering the establishment of a competing business in BJSSAM, which was wholly owned by BJSS. So even on the primary facts that the claimants say are supported by this email, one of them is that BJSS didn't just intend to end its joint venture with ACCL. It was already in the process of taking concrete steps to do so. We've seen that over the course of just a year, BJSS and ACCL voted to wind up all of the JV entities, and the 3 of those votes were before this email was even drafted. So bearing that context in mind and reading this email through, not through the predetermined lens of a dishonest scheme, but through the lens of a commercially minded business question of whether it even makes sense to keep a private banking business on the ground in the DIFC. What you see Mr. Carton explaining is the market and explaining what would enable BJSS to attract talent, explaining how to put in place a commercially effective business that was within the risk tolerance of the bank as a whole, bearing in mind that BSA earned in profits less than $1 million in 2013. So one should be asking these questions about what is it worth being on the ground in these circumstances. So this jurisdiction, I think, is hoping everybody will have this conversation. So what the court does not want to do through the law is chill business planning discussions and cause commercial parties to say, well, if I've had one unsuccessful venture here in the DIFC, and because I'm a director and still in the process of winding it up and it didn't work, I'm now painted with unlimited duties that extend into infinity and can't even think about whether or not I or my employer should consider others. So to condemn this email in and of itself, we would say would be doing precisely that. So to the second phase, the sharing of business information. Now we've already gone to the documents in which they say the information they allege to be confidential was shared. We say that the information does not have the character of confidentiality as to BJSS. And this is on the basis both of the BSA corporate constitutional documents and on the basis of historic practice of the parties. So if you go to the shareholder agreement, which is page 988, we go to Article 11.2C. This provides that the company shall provide each shareholder with such further information as each shareholder may from time to time reasonably request as to all matters relating to the business or affairs or the financial position of the company. And BSA is bound by this. They signed the BSA entity as an entity signed the deed of adherence, and this is at page 1016. BSA covenanted that it would observe, perform, and be bound by the terms of the shareholder agreement. I've already taken the court through the document showing past practice of sharing RM, performance, and salary and bonus information, so I won't revisit those. But in addition to the one that I did already take the court to, I'll just note that there's another one from 2011, and that is at bundle pages 1087 and 1093. So the claimants seek the information that the information shared by Mr. Carton was in furtherance of a fraudulent scheme, and we say this fails for 3 reasons. First, the court has to take into account the context set forth in the particulars itself that Mr. Sassoon at that time was actually poised to meet with Walia regarding the windup of the joint venture. And so one has to assume they had intended to have financial discussions at the time, and not even just assume, the contemporaneous evidence makes it clear that that was the plan. So there's an email dated 27 December 2013. It can be found at page 1332 of the bundle. And Mr. Walia emails Mr. Sassoon about their upcoming meeting on the 7th of January and asks Mr. Sassoon if there's anything Mr. Sassoon would like him to bring. Mr. Sassoon responds asking for financial information. The only thing that would be good to have is the balance sheet and P&L of Sarasin-Alpen. So if you're going to negotiate to the end of a JV, whether as a sale or as a pure wind down, you do have to understand the financial position of the company. And the only way you get to a negative inference about Mr. Sassoon's receipt of the business information is if you view it through the circular lens of already assuming a dishonest scheme exists. Second, as a short point of contractual construction, what is meant by the phrase in the shareholders agreement, all information relating to the businesses or affairs or the financial position of the company? We say all means all. I mean, it really just says if you ask for information, you get it, and it doesn't set forth a procedure or any restrictions on the shareholders on asking for information. Third, the emails that are alleged in the particulars are entirely consistent with past practice. There's a demonstrated track record of such information being shared. And so there are cases that we cite. The Duomatic case is one that basically says that whether or not an act is reasonable, it must to some extent depend on the way in which matters have been handled in the company in the past. That is at 375, page 2264. And then the fourth point on this is that we would just ask the court to note the circularity of the logic required to suggest that there was a fraudulent scheme of which the sharing of information was in furtherance, thereby proving the existence of the scheme. This is, of course, not a valid basis on which to prove a fraud allegation. So the third section of the scheme, as they allege it that we see it, is the inference that BSA's business information was shared with BJSSAM, which we had some discussion on earlier. This is nothing but an inference. It's found at paragraphs 55 through 57 of the particulars of claim. And so the notion that this inference works in practice, we say, is fanciful. The claimants do not allege with whom Mr. Sassoon shared this information and suggest throughout the particulars that they do not have access to such information, even though they are aware of the person who did the hiring at BJSSAM. And so they'll note that Mr. Clinton's name doesn't appear anywhere in the particulars of claim, which to us appears to be a conscious decision to omit his name from the particulars, leaving it to the reader's imagination to see who conducted and possibly even who received this information, even though that is explicitly denied as a factual matter in the information received by the liquidator during his investigation. So this commercial fiction obscures the facts before the court, which would tend to prove that a clean team was used to do the hiring at BJSSAM that did not risk a fiduciary duty breach by BSA directors. The inference, we would say, therefore, sidesteps the pleading requirement the claimants would have to meet, namely that Mr. Clinton received BSA's confidential information via BSA's directors. But we know what happened instead on the basis of at least Mr. Kapoor's email is that he himself provided his salary expectations. So in their skeleton for the first time in paragraph 133, they say they identify the knowledge recipient as James Cunningham, but what they actually say about Mr. Cunningham in the particulars at page 47 is that according to Mr. Walia and an email that he wrote, that Mr. Cunningham was telling BSA clients that BSA and BJSSAM were set to merge, that he would take over their accounts. Now, there is no pleading or other evidence that a merger was ever considered. And by October 2014, Mr. Cunningham was no longer employed at BJSSAM. So, and you only need to look at his LinkedIn account to see that. So this begs the question of what knowledge Mr. Cunningham is supposed to have received from Mr. Sassoon, which it appears, if any at all, was wholly inaccurate knowledge. So we say that this communication just didn't happen. The particulars are therefore pleading facts based on statements by a witness that it says lacks credibility, and where there's no suggestion anywhere else in the particulars that either of these supposed facts he was communicating were anywhere near accurate, where they're readily disproved with publicly available facts and asking the court to find that as a reason to sustain a fraud claim. Again, we do not ask the court to make conclusive factual findings in this regard, only to make a determination that the inferences pleaded by the claimants do not meet the pleading standards. The fourth sort of phase of the scheme as they plead it is this omission to procure a sale of the business. which they say is a violation of the best interest duty. Now, the legal authorities, as we've discussed, consider that to the extent a director ever has an affirmative duty to act, that duty or those duties arise only in relation to the duty of care. A director has to do his or her job and has to do it up to a certain standard, but the cases that speak about the remaining duties really do so in the proscriptive, not the prescriptive. So whether the breaches alleged by the claimants are dressed up as profit rule, conflict rule, or best interest breaches, they don't work because they all concern the defendant's powers and responsibilities as really BJSS employees and officers, not powers and responsibilities of them as BSA directors. The Howard case that we took the court to, it's also useful to demonstration that the court will not find a breach of fiduciary duty by a director in circumstances where they do not pursue a transaction that the relevant approvers or other stakeholders find commercially undesirable. And the citation for that is at paragraph 38, which can be found at 5541. So we would say that the problem is applying the best interest duty owed to BSA as a means of requiring the individual defendants to use their positions at BJSS to influence what BJSS did as a shareholder, or even apparently what BJSSAM did as a BJSS subsidiary. That is not an appropriate application of the fiduciary principles. It's not coextensive with the rules. Fifth is the negotiation of the windup. These allegations say that Mr. Sassoon and Cooke are in breach of their fiduciary duties to BSA for representing their appointed shareholder in negotiations with the other shareholder. Taken to their logical conclusion, what they say is that because the windup of the company terminates the existence of that company, it is never in that company's best interest. So if viable, this sort of infinite theory of the best interest duty would cast doubt on the ability of a director or former director to ever represent its corporate shareholder, certainly in any JV. And this would have stunning repercussions on every corporate governance model operating in the DIFC, as it would require that shareholders deputize unknowledgeable persons to negotiate matters of corporate existential importance. This cannot be what is required. We've already discussed the transfer of the business at length, and so I'll just move on to sort of a summary of what we say is that the more granular points as to each individual defendant are contained in our skeleton, so I will rely on that to address those. But what this exercise establishes is that the only allegation made by claimants that itself could potentially violate the various duties alleged is the inference that Mr. Sassoon forwarded BSA employee compensation information to BJSSAM. They make that allegation generically, not even mentioning whom they believe received it. And this is precisely the pleading strategy disallowed by cases where they say that what claimants cannot do is start from an assumption of dishonesty and then hope that their case will turn up in disclosure. The breach claims rely on it, the unlawful means conspiracy relies on it, and the vicarious liability allegations rely on it. Just very briefly on dishonest assistance and knowing receipt. The claim against Mr. Sassoon as a dishonest assistant also appears to undermine the primary case theory that Mr. Sassoon was a primary wrongdoer who engaged himself in breaches of fiduciary obligations at BSA. At the very least, it fails to distinguish which of his actions were primary wrongdoing and which were dishonest assistance. In truth, these contradictions simply illustrate that in substance, the claimant's central case theory depends on forcing fiduciary obligations onto BJSS, despite the express provisions otherwise in BSA's constitutional documents. But in any event, we would say that the claimants failed to plead the fraudulent design element as described in our skeleton. Finally, on knowing receipt, the claimants newly claim in their skeleton that James Cunningham is the knowing recipient at BJSSAM, but they don't make that allegation in the particulars, and there's no indication of what he received. For the reasons detailed in our skeleton, to the extent the claimants rely on their confidential information contentions, these contentions rely on flawed assumptions with no factual underpinning, and in any event, information is not property that is capable of forming the basis of a knowing receipt claim. So just in conclusion, we are 10 years after the events in question. And for comparison, BSA only started trading in 2005. So we now have a greater gap between the shareholder vote to wind it up now than for the length of time that BSA was a going concern. The claimants laid the blame for the delay at our feet, but even assuming all the defendants had waived jurisdictional defenses and proceeded directly to strike out, we would be having this dialogue 9.5 years into the events or after the events in question. That is a product of the claimant's failure to progress the liquidation, not tactical choices by defendants. So intersecting with that, we just learned 2 days ago what the subject property is that forms the underpinning of the claimant's transfer thesis. We would suggest that this is inappropriately late in the game for claimants to be finally articulating their case. In addition to the substantive problems with this pleading, even accepting arguendo goodwill as a proper basis for a property transfer theory, at what point does whatever goodwill is alleged to have made its way to BJSSAM just become BJSSAM's on account of its own brand name and service level, which are the things that typically make up goodwill? It's such an ephemeral concept. How 10 years later is the court supposed to dissect it from the organic goodwill of the fifth defendant? So the claimants attempt to paper over these problems through unparticularized pleading, a menu-based fraud theory, unjustified factual inferences, and this puts the court in a real position of difficulty because this opinion is poised to become very important opinion on the rightful scope of directors' duties in JVs or indeed in any group company situation, and these bleary pleading choices will only complicate the court's role in providing useful guidance to the legal and business community. For all of these reasons, they should be rejected. They are deliberate choices that do not meet the pleading standards, and they should be stricken out or in appropriate circumstances subject to immediate judgment.
Right. Is there? Where are we now? We're later than we should be, I think, by DIFC court time. So far as you're concerned, those are your submissions. Is that right, Miss Martin?
That's correct.
Okay. Mr. Shivji, what are you anticipating the length of your submissions will be?
I will reflect on it overnight, but I'm hoping to be quite a bit shorter than my learned friend. What are the likely sitting hours tomorrow? Does your lordship currently have a view on that?
Well, only so far as I'm concerned, as a start time, and
Yes.
I think we've got as much time as we need, so to speak, from what is effectively 12 o'clock Dubai time till closing time.
Yes. Understand.
I will reflect overnight as to the areas I might particularly want help on, and those where I might not. But I don't think I shall be able to tell you before then, in all probability.
I understand that, my lord. I mean, for our for our part, it has. My learned friend started out across her application and skeleton with a total of 83 points. I've been trying to keep my best track of what's left, and quite a lot of them have fallen away, and some of them are rather merged into a more amorphous point. But I think I understand the target that I need to hit tomorrow, and I will do my best to try and isolate them into pieces. I mean, some of the submissions we've had today rather weave together, but I will try and unpick it as best I can. But I must admit that the weaving together point rather illustrates the problem. This is a case that really ought to go to trial, and that what we're trying to do in this hearing is have a mini trial of 83 issues in circumstances where, as your lordship identified on one issue in one case, Lord Justice Chadwick, when he was an advocate, argued a point over 3 days. So it is quite difficult to cover all the ground in the detail that your lordship will need at trial, but I will do my best to try and boil them down to points of technical points of detail that could be properly dealt with in this way.
Yes, well, Sir John Chadwick belonged to a different era, and the manner in which cases took place in the Chancery Division in the 1980s is very different from the manner in which commercial courts deal with cases these days. So I don't think I can give you any sort of help at this stage as to what's going to assist me most. So in which case I will see you usual time tomorrow morning, 9 o'clock London time, 12 o'clock Dubai time.
I'm grateful, my lord. My lord, can I just say that in terms of tomorrow's timetable, it seems to me that we ought to set some time aside to work out where we go from here. Obviously, I appreciate in part your lordship may depend on whether your lordship reserves, but nonetheless, we probably do need to spend a bit of time just looking at that outlook.
What I was hoping was that you would be through by about 2 hours or thereabouts, and we could then discuss what happens thereafter.
Yes.
And deal with both security costs issues that arise in relation to the creditors meeting and so on and so forth, and come out with a form of agreed order. I anticipate that I would be likely to be in a position to give an indication as to my views on the strikeout and summary judgment application at the end of the hearing. Of course, that maybe Miss Martin may have more to say by way of reply, but a bit may then depend on those matters which you think it necessary to deal with, or I think it necessary for you to deal with. I'm put very broadly, as Miss Martin recognises, once one gets into factual disputes, there simply is no scope for this court on strikeout at all, really. And so far as summary judgment is concerned, it has to be a very clear case. And I regard this as quite a complicated mix of law and fact in relation to what's alleged, in circumstances where it might readily be thought that disclosure would provide material that is otherwise unavailable. And there's no secret in that being the approach of judges to cases of this kind. But you may wish to bear all that in mind.
I'm grateful, my lord. And so tomorrow, I mean, subject to where this all goes, your lordship may have noticed that at the end of our skeleton argument, our proposal is that if this application goes against the defendants, the court should set this down for trial. And that was a point that I flagged at the hearing in January. And it would be helpful. I heard all that Miss Martin had to say about the long time that this has all come to taking ahead. The flip side of that is that if the action does go on, we really could have a trial pretty swiftly. and it would be helpful to hear, if we end up in that, will be helpful to hear from the defendants how that's going to happen, rather than that they haven't had a chance to think about it.
Yes, well, I think that would be a sensible matter for the parties to consider. So in the event that the case does go on and there is no strikeout or summary judgment, I would be thinking of giving case management directions. I should say at once that my own availability later in the year is extremely limited. So that if I was to be the trial judge for it, and that would be the normal course to adopt, because it makes sense having handled it thus far, we will most certainly be looking at something in 2025, and possibly not even till the middle of 2025, but I'd have to have a look at my diary. If the parties could be ready earlier and everybody thought it was a sensible idea to have a fresh pair of eyes, ears and mind in a judicial capacity, then of course that is possible as well. All right.
One thing
yes,
I just might request that we all take consideration of is that a new liquidator might want a little bit of time to read in and consider whether or not this is a case that he or she wishes to take forward in this way. And I think that whatever proposed timetable is provided should provide for that.
Well, I think he'll have plenty of opportunity, but no doubt he will receive advice from, and one would assume take on board the advice of his professional advisors as to where this is all going. I mean, I've indicated already that it seems to me that in the end, there's probably not a huge amount of money here at issue. It all depends on what a valuer would put on the business of the of BSA. It seems to me, and I've obviously read what is being said about the nature of the relationship between BSA and BJSS, and the change in strategy, which meant that highly leveraged products were no longer going to be available, which plainly had the impact of cutting back on the profitability of BSA, and which would therefore no doubt affect its value as a business in terms of goodwill, client relationships, property, assets, whatever one may or may not call them. Anyway, there it is.
I mean, my lord, just on that, can I just leave you with a parting shot on that? Well, obviously, I hear what your lordship said, but I mean, I know your lordship's comments were only in the context at this very preliminary stage.
Yeah.
But the company, I think it's worth just bearing in mind that as at late 2013, the company had about $4.2 billion of assets under management.
I understand that.
That is not true.
I'll make my points, and my learned friend can make her points later. But the company had those sorts of assets under management, and they were generating very significant revenues. And of course, what the value in this business was that non-resident Indian market, the NRI market, that was mentioned in the relaunch plan, and whoever sort of secured the workforce and the relationships captured that non-resident Indian market, which was very lucrative. And of course, it was a matter. Of course, for BJSS, it had its own credit policy, but if there was a sale, it would have had to consider the possibility that that client base would go to another business that would extract more value from it. And that really is the point that we're arguing about. And the revenues to the company, the profits to the company were reduced in 2013 because, as Ms. Martin said, in that year, there were very significant fees for the litigation. But in previous years, it was generating very handsome profits. And with increasing assets under management, there was a prospect of very significant profits in the future as well. So, I mean, I know your lordship wasn't intending to lay down anything in particular on that, but I slightly bristle at the suggestion that the value of the litigation may be less than the cost, because that is very much up for grabs. And I know your lordship will in due course hear evidence on that. Your Lordship wasn't setting down anything, but I wanted to make that clear.
Yeah, well, of course, I speak from a position of profound ignorance in relation to the value of the business, and indeed, no doubt, disclosure if we get that far of what has happened at BJSS-AM, if that all be disclosable, will be a matter upon which valuers will want to give their views. So don't read too much into what I said, but I was proceeding simply on the basis of what I had understood from the evidence seen thus far.
If I may just correct a couple of the factual points that Mr. Shibji relied on there, which is that the 4.2 billion he cited is all of the BSA companies, not the Dubai entity. And so it is inflated in that regard. And as for the profitability in 2012, I think it was a couple $1 million. I mean, obviously it's more money than one would leave on the side of the road, but for a bank of this size, it's as the court says, it's not an incredibly profitable company that's going to lead to a $75 million judgment by any stretch of the imagination.
Well, that's for others to assess at this stage.
Of course.
To say, I probably shouldn't have said what I said because I know so little about the true facts. But anyway, the parties can take their own advice and decide where they want to go with it. And no doubt a new liquidator will do that. And no doubt BJSS will consider the position too. All right, let's leave it there. You both have put down your markers on that. And that's all that's necessary from your point of view. Nobody's committed. And I'll see you all tomorrow then.
Very good.
Thank you very much.
Would you just like to sign out? And I'll have a quick word with the associate if I may.